Good evening, everyone. Welcome to the Hillsborough Township Planning Board meeting of December 5th, 2024. Please join me in a salute to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be advised this meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, otherwise known as Sunshine Law. Notice of the 2024 annual meeting schedule has been provided to the officially designated newspapers, Township Clerk, posted on the Township's website, and available here at the Hillsborough Township Municipal Complex. In addition, application documents and plans have been made available on the Township Civic Clerk website at least 10 days in advance of this evening's meeting. Complete application files are available in the Planning and Zoning Department for inspection in accordance with the public meeting notice. With that, may I have a roll call of Planning Board members and also Board and Township professionals, please?
Mr. Vandervliet is absent. Mr. Wagner?
Here.
Mr. Radowitz?
Here.
Ms. Smith?
Here.
Mr. Vitale?
Here.
Mr. Debb?
Here.
Committeeman Lapani?
Present.
Deputy Mayor Ciccarelli?
Here.
Vice Chair Peason?
Here.
Chair Sirachi?
Here.
Mr. Coyce?
Present.
Ball?
Here.
Mr. Bernstein?
Here.
Mr. Mayhew?
Here.
And myself and the videographer are here.
Okay, excellent. Thank you and welcome, everyone.
Really here? Man never speaks.
Okay, we do not have any meeting minutes for consideration nor resolutions. There is no planning board business. So I will move to business from the floor for matters not on this evening's agenda. If anyone would like to provide any commentary to the planning board, please come up, state your name and address for the record, please, and please keep comments limited to 5 minutes.
Hi, Greg Colmer, Taylor Avenue. Forgive me, Chairman, I have something that is on the agenda related to campus. And last time they had the update, there was no public opportunity to make comment or to question the witness just because they're providing an update. So I can certainly reserve or I can say no.
Later.
What, later?
Campus.
Yeah, campus is on the agenda. We'll wait till campus.
As long as there's an opportunity just to open up. Last time there wasn't. That's why I'm
Okay.
up here now. Thanks.
Yep, thank you.
Maria Janusik, 720 East Freck Avenue, Manville, New Jersey. I'm also a Hillsborough Township property owner, Block 86, Lot 32155, Camp Lane Road. I was present at the last planning board meeting that was held on November 14th this year for the public hearing of the Weston Road LLC application. From what's been discussed at the public hearings, the applicant is attempting to appropriate property that is owned by the Township of Hillsborough. There have been several hearings for this application, but this fact was not disclosed at any of the prior meetings. How is this application with the applicant's building sitting on Township property allowed to go forward? A letter dated March 15, 2022 had been sent to the Hillsborough Township Committee. It was sent care of Sean Lapani, Committeeman Lapani, who was the mayor at the time. And so how can someone build on property that doesn't belong to them? And how is that application allowed to go forward when you had people who had hired an attorney to represent them from the Hearthstone development, and now we're finding out that the applicant has his building sitting on land that doesn't belong to him? There is a deed that the township owns that property. There is the letter from 2022 in regard to this. And how is this allowed to go forward?
Unfortunately, I can't comment on anything here because that is still an active application, and I do know at the last meeting we had stated, once I'm going to say witnesses.
The matter was completed.
Right,
We would address the issue.
We would deal with that issue at the end.
I'm sorry, once what?
We would deal with that issue once everyone is completed with their presentations.
Okay.
So it's still active, so there's nothing I can comment at this point.
Okay, but how can this be active if they don't own the land and they have their building sitting on the land?
Mrs. Janusik, this is a pending application. The board cannot comment on a pending application in the absence of all the parties involved in the application. If you have anything else regarding any other matter, be my guest.
Yeah, well, but the thing is, during those meetings, we don't have the opportunity to
Mr.
say
Chairman.
anything when the
Ms. Janusik,
parties are present.
you will have the opportunity at the appropriate time during that application hearing. Is there any other matters?
Yeah, I wanted to ask, in regard to the position of the planning board attorney, is that something that's put out for
Yes.
Yes.
qualifications? Has there been a choice made already, or who makes that choice?
The planning board makes, the RFP is out, the planning board makes that choice, and if you'd like to apply for it, be my guest.
Okay.
The request, Ms. Janusik, the request for proposals for all professional services are currently out. They're due in, and bid opening, I believe, is the 10th of December.
Tuesday. Yes.
Tuesday. At that point, they will be consolidated, and the appropriate people will review them and make the decisions based on the qualifications of the applicants, like we do every year.
So the Hillsborough Township Committee puts out the request for qualifications?
Request for bid, yes,
For
or
bid.
request for proposals.
Request for qualification / proposal.
Right, correct.
It's on the town website, Ms. Janusik.
And that is from the Township Committee?
That is from the township.
From the Township?
Yes.
All right, because I think it was in the minutes of the Township Committee. So who makes the decision? The planning board?
The ultimate decision, yes, we would take a
I'm
vote.
sorry,
Planning board the planning board makes the decision, not to jump on the terms, for the attorney for the planning board attorney, the township committee, and makes the decision for the township attorney and all the other professionals, the engineering, et cetera. So it,
And
to answer your-
the zoning board
and
for
the zoning board makes their turn. So it's the same way it's been done for the last 20 years that I've been involved with the township, as do the other townships around.
25.
Right. We're not the only ones that do it.
And when professionals submit their qualifications, is that available to the public to see who had applied for that position?
I don't know if that's available to the
I don't
public.
believe it's available until after the board
decisions.
makes a decision.
Right.
And then it would be available?
Yes.
Thank you.
Me.
Anyone else for matters not on this evening's agenda? Okay, seeing none, we're going to move on. We do have consideration of an ordinance 2024-16. It's an ordinance amending Chapter 188, Land Use and Development, Article 9, Tree Preservation of the Code of the Township of Hillsborough, Somerset, New Jersey, to address the New Jersey Department of Environmental Protection tree removal requirements. David, or is it council?
Thank you, Mr. Chairman. Ordinance 2024-16 proposes to amend the Township Code to address the New Jersey Department of Environmental Protection's tree removal requirements. The 2023 Tier A MS4 permit renewal requires permittees to, and at a minimum, to adopt and enforce a community-wide ordinance to control tree removal and replacement for all types of properties where the municipality has jurisdiction. The township's existing tree ordinance did not comply with those requirements, and that is why a new ordinance was proposed. The public hearing will be at the December 10th Township Committee meeting.
Okay, thank you. Mr. Bernstein?
I believe it's the recommendation of the planning department that the township planning board concur with the ordinance that has been introduced by the township committee and return it back to the township committee for their action. Is that correct, Mr. Coyce?
That is correct. It is consistent with the master plan.
Thank you. Is there any comments from the dais? Okay. I don't have to open up the...
I'll just point out.
Is a motion to concur with ordinance 2024-16, an ordinance amending Chapter 188 of the Land Use and Development section of the Township Code in regard to addressing the New Jersey Department of Environmental Protection tree removal requirements. That same is consistent with the Township Master Plan, and that the Planning Board is recommending to the Township Committee adopt on second reading at a subsequent Township Committee meeting this year, which I believe is next Tuesday.
Correct. December 10th.
Thank you. I have a motion to make that resolution. Go ahead,
I'm sorry, who? Thank you.
Mr. Wagner.
Second.
Okay. We have a second. Roll call, please. Oh,
I was just going to reiterate that this was part of us maintaining the guidelines and the DEP mandates for us to address all these. And, we always look at ordinance, but this is strictly just filling the guidelines that they've provided, right, Mr. Coyce? It's
Correct.
nothing overreaching more than what they've asked us to do.
Correct. It is a mandate.
okay. Before we go to vote, any final comments? Okay, roll call, please.
Mr. Wagner.
Yes.
Mr. Radowitz.
Yes.
Ms. Smith.
Yes.
Mr. Vitale.
Yes.
Mr. Deb.
Yes.
Committeeman Lapani.
Yes.
Deputy Mayor Ciccarelli.
Yes.
Vice Chair Peason.
Yes.
Chair Sirachi.
Yes. Okay. Moving on to this evening's public hearings. First up is Hillsborough 206 Holdings, LLC, file number of 18-PB-07-MSPV. It's a 2024 amended site plan. The time of decision is January 22nd of next year. This is Block 202, Lot 104, otherwise known as 871 Route 206 North /2 Schindler Court. The applicant is seeking amended preliminary and final major site plan approval to eliminate the construction of 2 retail buildings in the property. In lieu of, it's proposing to construct 2 additional residential buildings to contain 24 units, of which 6 will be affordable units on the property located in the mixed-use inclusionary district and the architectural and site design overlay zone. So with that, Counselor, I'll turn it over to you.
Thank you, Mr. Chairman. Members of the board, Richard Hoff, law firm Biscayne Hoff. I'm here on behalf of the applicant, Hillsborough 206 Holdings, LLC. As Chairman indicated, we're here tonight for an amended site plan. As I know from the faces of the members of the board, I've been up and down over the years with this one. This is a project that is built in large part. It's the Hillmont project. It was originally approved back in 2019, 175 units, inclusive of affordable housing, part of the Townships Affordable Housing Compliance Plan. Interestingly about that approval, it also required a mixed-use component of 12,500 square feet of non-residential development that was approved along with the original application, and contained a condition that talked about having to report on the status of the non-residential development over the course of construction, such that the idea was don't finish the residential without the non-residential being incorporated. COVID happened, a lot of things happened, and we were getting traction on the retail despite our best efforts, and there was discussions had and eventually an ordinance adopted earlier this year that allows for the incorporation of 2 additional residential buildings in lieu of 2 of the non-residential buildings. As anyone who's been out to the site probably knows, the first non-residential buildings under construction, and we're talking about just a small area of those remaining 2 buildings. The site is disturbed, as the board's going to walk the board through. But here tonight, we're just effectively swapping out 2 non-residential for 2 residential buildings. So with that introduction, I'm going to turn it over to James Ward, our engineer, who can walk the board through.
We're going to swear you in over there.
Swear in testimony you give tonight, give the truth, the whole truth, and nothing but the truth. And your mic cut off, but it is. Just that you spell your name.
James Ward, W-A-R-D.
Let's see. Bring this up on the screen first, please.
Okay. Is it? Try it again.
While we're figuring that out, let's start with Mr. Ward, your professional and educational background, please.
Yes, I'm a licensed professional engineer. My license is in good standing.
Gotta move the mic a little closer.
Closer? I'm sorry. And I've provided testimony in front of this board previously.
And been qualified in the field of civil engineering.
Correct.
And you're familiar with the application detail?
Yes, I am.
Mr. Chairman, I'd offer Mr. Ward's qualified in the field of civil engineering.
Okay, any objections from board members? Head shakes no, we accept. Please proceed.
Mr. Ward's license is
Very good.
current. Mr. Ward, your licenses are current.
Yes, correct. Currently in good standing, in current. So the first illustration I have here is an existing conditions aerial view that shows the current conditions of the site. You'll see that all the residential buildings are pretty much built out. The clubhouse is built. Retail building A is built, and the pad site for the other two retail buildings has been prepared and ready for construction. The next slide I'd like to show. Oops, sorry. Hold on one second. Is what was previously approved for the site. You'll see in that upper left-hand corner, buildings retail A, B, and C. B and C are the ones that we'd like to remove and replace that with two residential buildings, which are pretty identical to the ones that were already put up there and constructed. So next slide shows the amendment that we're proposing to that site plan. Buildings 15 and 16 are the two additional buildings. Retail A will remain. The access for those two residential buildings is going to be exactly in the same spot that the previous driveway access was for the retail. So we're going to use that for the residential buildings, and we're going to provide another access point on Schindler Court so we could have circular movement throughout that retail area. The next plan is basically just a blow up of that sheet.
We're going to make this A2. The previous sheet was A1.
There was an aerial before that, too. So that should be A1.
All right, this is A3. Okay, sorry about that.
Yes. So each one of those residential buildings will have 12 units. So a total of 24 units are proposed. 6 of those are affordable. There's a total of that would bring the entire project up to 199 units and 48 affordables. The proposed residential buildings, I'm sorry, I lost my spot there. Retail building A is to remain where it was, and I think I just said that on the other slide. I'm sorry. This detail shows more detail of what is proposed. There'll be screening behind the residential building. There will be a fence, a solid fence, like previously was provided between the last building, that was building 14, and the retail. So we're going to duplicate that, just move it over 2 buildings with screening. And we're also proposing a park area in between the retail and the residential buildings. And that would bring me to the next slide, which shows a more detailed view of that park that we're providing. It'll have a tot lot for 2 to 5-year-olds with play equipment. There's a seating area inside and outside. That park area will be fully enclosed with the gate access. The fencing along 206 would be a solid PVC fence that would match what was existing out there. Also in between the residential building and the park, that portion would be a solid PVC fence, and the remainder would be an aluminum picket fence with gate access. Like I said, might have been stated previously that the entire project reduces impervious cover 893 square feet. The motor vehicle surface is reduced even more than that. There's a slight increase in building coverage, so the net difference is 893. So the actual reduction in motor vehicle coverage is more than that, and I know there's a question regarding whether that might be de minimis for the project or not. But Rick, if you want to.
Sure. Let's clarify that point. So there's a bit more building coverage, but that increase is being offset by the reduction in the motor vehicle parking area previously associated with the retail?
Correct.
Okay.
Yes. So the point being how that relates to our stormwater, and we were of the opinion that there's no impact on our stormwater. So, in fact,
So with respect to stormwater and really with respect to just the entirety of the site, nothing needs to change from an infrastructure standpoint to accommodate these two residential buildings. Is that correct?
correct.
We don't, the buildings or the basins don't need to get bigger. The entrances aren't impacted at all. Everything remains the same. Is that correct?
Correct. Yes.
There was also a question that was raised relative to the traffic impact associated with going from the retail uses to the residential uses.
Yeah.
We
And
submitted a summary of that
correct.
difference?
Correct.
For those-
There was a reduction in AM, PM, and weekend peak hours. In all three of those cases, there's a reduction in traffic from the site.
Okay, so we actually end up net positive on the traffic demand as well.
Correct.
Okay. I'm sorry, go ahead.
Oh, I'm sorry. So and I just want to go through the parking that we're compliant with parking across the board. I could give you lots of numbers. We have 407 spaces required. We're providing 419 spaces. The retail requires 16 spaces. We're actually providing 24 in that area. The residential requires 319 spaces. There's a remaining 395 spaces on site, so we're increased on that. So we don't have necessarily a shared parking situation. We're over-parked on both of those. We provide enough ADA spaces. 9 would be required for the whole entire site. We're providing 19, which are basically distributed throughout the site for convenience. EV parking, the retail would require 1. We're actually providing 2. The additional 24 units would require 8 spaces, EV-ready spaces, and the garages, there's 12 EV-ready garages provided for that.
Okay. And so those all comply with the applicable provisions, and then the township zoning provisions that apply to the site. Do we comply with all of those provisions as well?
Yes, we do.
So this doesn't trigger any setback variances, coverage, building pervious?
No.
All complies, correct?
Does not. We're well within those regulations.
Okay. And you've had an opportunity, we received a review letter from Mr. Mayhew. You've had an opportunity to review that?
Yes.
And was there anything within there, any suggestions or comments that we could not comply with?
No, I believe we could comply with everything in there, and hopefully my testimony, I went through and addressed all those. But all these comments, we could
And certainly we'll turn it over to Mr. Mayhew to correct anything that we missed. And
Correct.
Mr. Coyce's letter, I don't think there was anything that we needed to specifically address that we haven't, but again,
No, correct.
Mr. Coyce will point that out for us. We were in receipt of an additional review letter that we got today relative to the Environmental Commission. And the thrust of, well, the first part raised was a correction of the tree count. This project complies with the requirements of the ordinance relative to the provision of trees,
Yes, correct.
but we can correct any count error. I think that raised a
Correct.
discrepancy
Yes,
with the.
we'll review that, and if we need to add some more, we certainly will add more trees.
I think the comment was there wasn't a deficiency. The question was exactly how many above
Yes.
the requirement.
Yeah.
Okay.
And we'll provide that information.
The more substantive comment raised by the Environmental Commission's report was the applicability, as the board knows, stormwater regulations in New Jersey have changed since this was originally approved. This project complies with the regulations that were in effect in 2019 when it was originally approved. All of the stormwater aspects of the project have been incorporated and built. But a question was raised by the EC as to whether the project now needs to comply with the new stormwater regulations because we're in for a revision. Our position is that this would not be required to provide for the entirety of the site to comply with the new regulations. Frankly, that's not possible because the stormwater already exists. However, we did have the opportunity to review the potential for incorporating some infiltration and even some water quality provisions on the new portion. We had the opportunity to talk with Mr. Mayhew. We would be agreeable to providing some infiltration as well as some water quality features. Mr. Ward, where would be the most logical place to incorporate those?
Yeah, we could provide some green infrastructure. Let me go back to one of the other slides that shows the site. Like Road F here, there's 2 inlets. We could provide green infrastructure inlets for that. We have a perimeter roof drain system. We could provide pervious piping for that and promote groundwater recharge.
So rather than argue that it's not applicable and get into a disagreement about whether it applies, we feel that even if it did apply, given the nature of what this is actually proposing, those types of provisions, which we'll work with Mr. Mayhews to ensure that, it's sufficient, we believe that meets the if not the letter, certainly in the intent of the revised regulations, because we will be incorporating the type of features that appear in the 2023 revisions to the DEP regulations. So obviously nothing we can do with the balance of the site because that system exists, but we will incorporate additional measures to the satisfaction of Mr. Mayhew's office for this additional portion. So I believe that addressed the thrust of the EC's recommendations and or concerns. So with that, Mr. Chairman, we didn't have anything else. I mean, we have Mr. Raker, our architect here, if you would like to hear from him, but not to steal his thunder, he's going to come up and tell you these buildings are going to look just like the other ones on the site. So I think I'll save us the time. So obviously it's in our interest to have it look cohesive, and that's what we did with the design.
Okay.
So with that, we obviously available to answer any additional questions from the board professionals, members of the board, and members of the public.
Okay. Mr. Mayhew.
Thank you, Mr. Chairman. I did have an opportunity to talk to the applicant's engineer and attorney, Mr. Hoff, and I discussed the EC committee review letter. I suggest that Mr. Hoff's offer of introducing some manufactured treatment devices for water quality and infiltrating some of the roof runoff from the 2 proposed new buildings is a satisfactory way to address the EC's concerns. We believe that it's not totally clear at the DEP as to when an application is considered new versus an amending an older one and how much amendment can occur before triggering all the new regs. So I think the offer presented is a very fair suggestion how to address the stormwater criteria. I just have 2 other items to note in our review letter. I understand the applicant's willing to address our comments. I just want to clarify on page 3, where our office is recommending a little bit more landscaping along 206 behind the new proposed, because that would have been retail and it wouldn't have needed to be screened, but now it's residential.
Sure.
So would your office be willing to?
Yes, absolutely.
Some evergreens in that area?
Yes.
Okay. And the only other comment that I didn't hear any testimony on, and this is maybe for the applicant and the board to discuss, is the parking does meet RSIS criteria, but in order to meet that, what it's saying is for every 1-car garage and 1-car driveway, RSIS allows you to count that as 2 parking spaces. And our office experience has been that can be difficult. Sometimes garages get used as storage, and sometimes people don't feel like moving their car in and out of the driveway. I'm just wondering if there's an opportunity, unless the board's experience at this site is that there aren't any problems, is there an opportunity to look at additional parking somewhere?
Yeah, we could review that, but I'm in my first opinion is I think we're maxed out. We were going to add some additional parking next to the clubhouse that was on the site plan. I could see my rendering doesn't show that, unfortunately. But over in this area over here, I think we're adding 6 spaces. So we could take a look at that. Maybe we could add 8 if we can. I know in your review there was something regarding widening the road. That would block access to Building 15, and we would possibly gain 2 in front of Building 16, but at the same time, none of the rest of the site doesn't have that feature. Someone would have to actually go down the street, make a U-turn in somebody else's driveway, I guess, and then park on the street. So that keeps it basically, cordoned for the residences of those 2 buildings, really. So
This is more, as I said, it meets the RSIS. I guess it's more of an opportunity if the board has heard feedback from residents of that area that there's issues on site parking, that now's an opportunity to try to address it. If not, then I find Mr. Ward's testimony satisfied, and if we're willing to add a couple spaces here and there, that would address our concern.
we're willing to look at that, sure.
Thank you.
Mr. Mayhew addressed Stole My Thunder appropriately. I have nothing further or any concerns. Thank you.
Okay. But we haven't received any calls or complaints or feedback as to the parking situations?
Up to now, no. And usually our phones, they know how to reach us. We have not received any complaints about that.
Mr. Hoff, what's your capacity of the project right now? Are you full? Everything that's available is rented?
Yeah, we're fully occupied, and when the question got raised, I just asked my client, and it's not an issue that we've heard from residents.
Okay.
And they would know how to find us too.
Obviously, you would know. Just as a question, have you found a tenant for your retail space yet, or are you just?
Yeah, Building A is fully tenanted.
Good for you.
Yep.
That's all I have.
How many tenants?
2.
Okay. Any other board members? Comments, questions?
I just have a question out of curiosity. If you could clarify, what's the variance in the square footage between the existing plan and the new plan? I know you kind of touched on that, but what is the additional square footage?
There's a reduction in impervious cover of
No, just the square footage wise.
The building
square footage.
Of building coverage? Oh, the building coverage actually gets slightly increased. Those 2 residential buildings are larger than the 2 retail that it's replacing. I don't have that number in front of me exactly. I think it might be on the...
Building coverage goes from 11.2 to 11.8, but I wouldn't do that math. Mr. Ward would have to do that math into what that means in terms
All right, if you don't have it handy.
Yeah.
I was just curious. Thank you.
11.8, what, percent?
Yes.
1,000?
Correct.
Yes.
Across the entire site.
Yeah. Mr. Ward, you mentioned duplicating the fence that runs vertically. Are you duplicating the fence or are you moving?
That fence will be moved.
So the one that's there will be removed?
Correct.
Okay,
yes.
so there won't be 2 fences?
No, correct,
okay.
yes. We're duplicating that theme and moving it down to the end of the new residential complex.
All right, thanks.
Anyone else? Okay, can I have a motion to open to public, please?
So moved.
Second.
All in favor?
Aye.
Aye. Okay, if there's anyone from the public that would like to ask this witness anything on his testimony, please come up to the mic. State your name and address for the record, please.
Susan Gullah, Fort Hunt Club Road. The 6 additional affordable that you have listed, I'm not sure who this goes to. Does that get credited to our next round?
The answer to that is yes.
Okay, I wasn't sure where that one went. On those garages, I remember a problem with garages and parking at another development. Is each one of these garages attached or assigned to or has access only to a particular unit?
Yes.
Okay,
yes.
so it's nothing that could be rented separately, so to speak. Okay. On the parking spaces, did you say for the remaining retail building?
Yes.
Sorry. Did you say 16 required, 24, or was it the other way around?
Yes. Retail A requires 16 parking spaces, and that parking field has 24 parking spaces.
Okay, 24. And you're going to have 2 businesses in there?
That's currently the plan.
Yes.
Okay, that just seemed a little low for 2 businesses. Okay, thank you.
Thank you. Any other members of the public?
Maria Janusik, 720 East Freck Avenue, Manville, New Jersey. Is this application a part of a settlement agreement?
The original application was part of the township's affordable housing plan, but it was not the subject of a formal settlement agreement.
So there was no settlement agreement between the applicant and the township?
Correct.
Thank you.
We convinced the applicant not to become an intervener by bringing an application forward and working with them as to what the application would look like, therefore avoiding them going through the process and getting something that the township wanted without having to wait for the court to deal with it separately. They are, however, part of the township's agreement with Fair Share Housing Center as part of its overall affordable housing plan for round 3. And these units, as I indicated when Ms. Sculliford asked the question, would be toward round 4.
Thank you.
Any other members? Okay.
Mr. Chairman, I have nothing further, unless the board has any further questions. We appreciate the board's attention to this project, not only tonight, but in the years since 2019. It's been a challenge, and we appreciate the cooperation both of this board and the members of the Township Committee.
Thank you. Board members? Okay. So now we will open it to the public again for their last chance as at the proverbial apple. Any final comments or thoughts? Okay. Seeing none, motion to close to public.
Second.
All in favor?
Aye.
Aye. Counselor?
Mr. Chairman, there is an application an amended application before you regarding Hillsborough 206 Holdings LLC, file number 18-PB-07-MSPV, the 2024 amended site plan for Block 202, Lot 4, known as 871 Route 206 North /2 Schindler Court. This is an amended preliminary and final major site plan application to eliminate 2 retail buildings from the original application, replace them with 2 additional residential buildings containing 24 units, of which 6 of those are affordable and will go toward the township's round 4 obligations. And it is located in the MUID-1 mixed-use inclusionary development zone. The applicant has placed before you the rationale for such. This board, most of the members have sat through this now more than 5-year application. Mr. Hoff has asked for rental space. Regarding this, discussions as to the issue of retail continued to come up. Attempts were made to try to address same, and the board and the applicant basically came to the conclusion before this application that the way to go was what is now before you this evening, which is 2 additional residential units that basically mirror the existing residential units, which applicant has indicated are fully occupied. And I assume the intention is these will be shortly after they are completed. That has been the history of this application. The units are included within the buildings. They are not separated into one. Is that correct, Mr. Hobb, just to conclude?
That's correct.
Thank you. and therefore they meet all the other criteria, and the applicant has indicated they will meet the conditions, both what they have agreed to on the record this evening and to meet the conditions and requests made by both Mr. Mayu as the board engineer and Mr. Coyce as the board planner, planning director for the township.
And we're not going to require Mr. Hoff to come here again.
Well, you could, but, you know.
Provide an update.
We did a ribbon cutting.
So with that,
Mr. Chairman, I'll make a motion to approve the request and the application as laid out by the Mr. Bernstein. And I'd also like to thank Mr. Hoff and his group for being flexible with us and asking and working with the board throughout this process over the last 5 years. And I'm glad to hear that you've rented that space.
thank you.
Motion.
Second, okay. Any final comments from the board members? Hearing none, roll call, please.
I need to check something for Eric before I put some red names on here.
What?
Names.
They're probably not eligible.
Uh-oh.
Call the roll. My other replacement.
Mr. Wagner?
Yes.
Mr. Radowitz?
Yes.
Ms. Smith?
Yes.
Mr. Vitale?
Yes.
Mr. Deb?
Yes.
Committeeman Lapani?
Yes.
Deputy Mayor Ciccarelli?
Yes.
Vice Chair Peason?
Yes.
Chair Srirachi?
Yes.
Thank you very much.
Okay, thank you.
Have a nice holiday.
Do the same.
Would you like to be booked for another meeting, Rick? We could bring you back sometime in the first quarter.
Okay, we're going to move on to the next.
And the next victim.
As I like to say, next opportunity. Campus Associates LLC with file number 20-PB-13-MSP as a 2024 update for Block 58, Lot 1.05, otherwise known as 4 Campus Drive. The applicant, which happens to be now a new property owner, is updating the planning board on the status of the project. Had been requested for every 6 months. And for this update, it was no later than the end of this year. So it's nothing like 3 weeks to go.
And we're going to ask that not only the applicant give an update, but the applicant make themselves available for questioning from the public.
Yes.
Which prior council was not. I will indicate to the board that when Mr. Policastro was here, this issue was raised and we got silence. And then we got notification that we now have a new owner. So it was my request of Mr. Coyce's office that council come, take his proverbial beating, that he give us a more detailed update on where we are based on the history of this application that precedes him, which his client unfortunately acquires by the virtue of the application. And I think he should introduce, I'm sure he will, and tell him where he is and whatever questions the board and the public may have. Counselor?
Okay. Thank you very much. Thank you, members of the board.
You might want to pull the
professionals,
thing a little
council.
closer.
I'm sorry?
Pull the mic just
thank you.
close.
There we go. And as
The base moves.
oh, there we go. We good? Okay.
Thank you.
Well, as luck would have it, I actually know Mr. Hoff. We used to work together many years ago. So it's maybe his last time here and my first time here. So, and our kids went to high school together. So, well familiar with Mr. Hoff, and happy to see him tonight. My name is Stephen Kessler. I am the general counsel of Fernmore Homes. We are based in Jackson, New Jersey, which is right down the road. And we are a family-owned business. We are real estate developers. We build, develop. We're our own general contractor, and we own and manage our units after we build them. And we keep them. We don't sell them typically. We have over 4,700 units in the tri-state area, Pennsylvania, New Jersey, and Delaware. And we have the reason we're here in Hillsborough, we acquired the project back in September from the prior owner. And we chose Hillsborough for a number of reasons. First of all, it's a great area for us. Strategically, we have two other projects under development that are fairly close, down the road in Plainfield and over in Branchburg. We're under contract for another project as well. So strategically, it sort of fits into our geographic area, and we like the project, we like the area. We like to think that Hillsborough is of those three, don't tell the Plainfield people or the Branchburg people, but Hillsborough is our favorite one, we think. This is an exciting project for us. Our company is owned by a gentleman named Jeffrey Fernbach. Jeffrey has been in the development business for the past 30 years. I came to work with Fernmore 5 years ago out of private practice and have not regretted a single day of my departure. I absolutely love the people I work with. Like I said, we're a family business, and we handle these projects from soup to nuts. We, like I said, we manage in-house, so that is our plan here as well. I want to give you just a quick update on the project itself and where it stands. Like I said, we acquired the project in September of 2024. After we acquired it, we then began to reach out to our mobilization team on the construction side. We began working with the township officials in the construction department in terms of getting the project ready to move forward. We continued to familiarize ourselves with the approved site plan that we have. We have since posted bonds for the project and mobilized our site work contractor and started to move equipment on site. So we're planning to begin our site work. Of course, with the cooperation of township officials, township engineer, township construction office, everybody's been a pleasure to work with so far. And like I said, we're in the mobilization process at this point. We've paid our escrows. I said before, we posted our bonds. The schedule is right now, weather permitting, with the winter months setting in. We're going to start our site work and hopefully wrap up our site work and infrastructure work by the time the weather breaks in the spring. Our plan right now is that in the spring, when the weather turns, we would begin vertical construction of our buildings, our first buildings. I'm working currently with a construction lender. We plan to close on our construction financing next month, and that is pretty much a 30,000-foot update on where we are right now, and that's the best timing I could give at this point. Like I said, it's been a pleasure working with the township so far. We feel very welcomed on this project. We also want to stress to the public that we like to be good neighbors. We are all neighbors ourselves somewhere. And like I said, we're a family business. So we like to be good neighbors. We like to make ourselves available to people who live around the project who might have concerns and help answer questions and help make the process as seamless as possible. So that's where we are now, and happy to answer any questions that the board might have, or the professionals or the public.
Okay. Thank you. Mr. Mayhew?
Well, we have no questions.
Okay. Ms. Coyce?
I have no questions.
Okay. Board members?
I'll just ask one because I know there's some public that want to ask you questions, so I'll give them the time that they deserve. But are you familiar with your company with all the requests and requirements? Because this was a pretty long application with some environmental concerns, and are fully aware and prepared to handle everything that's been requested by the board and the state and DEP.
Yes, we've thoroughly gone through the application, all of the prior hearings. I guess we're happy we weren't in the hot seat for those. Are quite contentious, and we saw the history there. But we thoroughly vetted the project and are prepared to move forward with it and meet all the requirements. Yes.
Any other board members? Okay. Going to ask for a motion to open to public.
Mr. Chairman, could I add something?
Sure.
I wasn't involved when this was originally approved, and I'm just looking at a little 11 by 17, but I just wanted to ask the applicant, are you aware of the, let's say, stormwater management issues that have occurred in the past along your western property line?
our engineer, as we had a discussion with, and by the way, we are keeping the same end. We're keeping the Van Cleef firm and Mike Ford as our engineer going forward. And one of the reasons we're doing that is for that reason exactly, because he's familiar with this. And yes, we are aware.
And I don't know the answer to this because I'm looking at one drawing, but I do understand that your stormwater management for this site is underground, I believe.
I believe so.
And that normally it's at grade, and normally that basin is a temporary sediment basin. Since it's underground, that doesn't give you the opportunity. Is there something that I'm missing on this drawing, that there is somewhere on your site a temporary sediment basin?
We would have to consult with Mike Ford on that.
I would ask that you get back to our office or David's office. Because I've been involved in projects where there wasn't, and it generally leads to problems downstream. Now, I know if it's not on the plan, I'm asking that maybe that someone should give that some consideration before breaking ground.
Sure. Yeah, we have a call with Mike tomorrow, so I'll bring it up with him, and one of us will reach out to David.
Thank you.
Sure.
Thank you. So now motion to open a public.
So moved.
Second.
Okay, all in favor?
Aye.
Aye. Okay, public, come on up. State your name and address for the record, please.
Here's your first neighbor.
First neighbor. Hi, how are you?
How are you?
Hi, Grant Culmer, Taylor Avenue. These are words that I don't know, so if you could provide some clarity, and that's just because of my ignorance. I heard the word mobilization. I don't know what that means. Can you provide more details of what mobilization means?
Sure, absolutely. So typically when we get past the if we purchase a property and we go through the approval process, typically we consider that the approval process, the design process. Once that's over and we've posted bonds and posted escrows, we go into what we call mobilization, which would be getting our contractors mobilized and out to the site, and so they can start their work. Yes.
Are you aware of the work that's already been done?
We are aware that there's been some site work done at this point, yes.
Could you comment on that to the board and to myself, perhaps?
I can't comment to the exact scope of what's been done so far, but we were just on the phone with our site contractor earlier today, and there's been some site work, possibly some grading that's gone on, but I don't have any details beyond that.
Would it surprise you to know that basically the entire site you were looking at has been devoid of all trees?
Cleared.
Thank you.
That does not surprise. Yes, that does not surprise me.
Cleared of all trees, and there's a huge mulch pile now waiting just for the winter months.
That does not surprise me, based on where we are.
Great. And there's that's what site work means.
Correct.
What else is imposed in sort of doing site work until you can break ground, because you're not going to be able to do it now?
Correct. So typically the way that we would do this during the winter months is there would be clearing, what we call clearing and grading. So we would clear the site, grade the site so that the elevations are, in place and ready to go. And then you'd start with infrastructure, which would be water, stormwater, sewer at that point.
Is this just because of your timeline, or could that have been, how long is that period of time, grading site work? A couple weeks, month?
No, it's hard to say with weather, with, there are various factors involved depending on how many other projects the site contractor might have going at any particular time. So it can vary. We're currently estimating that the site work portion of this is going to go on at least through to the spring. And of course, that's assuming we don't have any major blizzards between now and then. But that's
all of the site work is going to be done through the spring.
That's our hope.
Just getting the pad ready and everything else.
That's our hope.
But not digging ground.
Well, I mean, I guess there would be digging involved in the grading, but certainly not putting any structures in until the spring. That's the thought at this point. That could change. Generally, I will say this: with construction, it generally doesn't. In my experience. When we set a time period for doing something, it's rare that it would move forward. I guess it is a possibility, but typically, if anything, there could be some slight delays, again, due to weather or availability of contractors. Materials, in the past, materials were a major issue. They're less of an issue today, but during COVID especially, we had major problems getting materials on site.
Would your contractors, do you think, be concerned about any flood mitigation that's happening right now, that the site's cleared of trees, which is a flood sort of deterrent, or stormwater management of some sort, soaking in some of that water? Is that a concern for your engineers or construction officials?
I'm sure in the process of implementing the plan, it's all taken into account by the engineers before they, certainly if you're experiencing any specific problems, we'll make ourselves available if you need to reach us.
And how would we reach you?
I can give you my information.
Would you be able to state it here?
Sure.
I know a lot of our community members might watch this.
Absolutely. So I'll give you my direct dial, and then I would put you through to our project manager. Our project manager's name for this project is Jack Kennedy. Not kidding. That's his name is Jack Kennedy. Jack will be our project manager. You can reach me at the office at area code 732-719-5000. I am at extension 40. And I will direct you to the appropriate person if you have any issues at all.
Appreciate it. Thank you.
Absolutely.
Is it, if I recall, and I can't remember because it was so long ago, usually they do the certain periods they can't excavate because of the bats. I'm not sure if this application had that same restriction, but usually it's in the wintertime, correct? That you have to give a window.
That would be clearing the trees.
Clearing the trees?
Yeah, which they're all gone. So
yeah, but I'm saying that this gets usually done around this timing, if I recall. But that was a long time ago, and I don't remember.
But that's true, and that would only be if this was identified as a potential habitat area.
I don't remember.
And I don't remember. I wasn't involved.
You weren't there.
No.
Susan Gullo, Fort Hunt Club Road. This project backs onto Johansson Avenue. Okay, and you've already been in contact, I guess, with residents in that area. I don't know the specifics on it, but I know they had heard from FEMA, some of the homeowners over there. I don't know if these were changes in FEMA regulations or what happened. Is that going to affect your project at all or make any changes in what you were going to do to update that?
Not that I've been made aware of at this point. That's not that we've been made aware of. I could certainly ask our engineer, but hopefully not.
If you're talking about the stormwater regs, they wouldn't affect.
They got those letters.
They wouldn't affect this project because it was approved prior to the change. So they go by what was the regs that were at the time of the application.
Okay. Thank you.
As all applications are.
Maria Janusik. The campus application, is that part of the, does that have a settlement agreement?
Yes.
And so how does the change of ownership affect that settlement agreement?
The new owner is required to comply with all the requirements of the prior owner.
Was there a new settlement agreement
No.
created?
No.
And so is there also a agreement with Fair Share Housing?
No.
There was no agreement? They were not involved in this?
No. The agreement that was entered into from the parties allowed for transfership of ownership. Fair Share was aware of it. Fair Share approved it, as did the court. Not as to this party, but to the overall concept of a possible change in ownership. And not just for this application, but for any of the ones that went through the settlement approval.
So any applicant that had a settlement agreement, if the property changed ownership, nothing changed as far as the settlements, and no new settlements had to be written with the new owners?
No, they are required to accept the agreement between the original parties.
Okay.
So council's client basically took the project as is.
Okay. Would you know the reason why the previous owner sold this property?
It's a question for Mr. Kessler. So,
Yeah.
I don't represent the original owner, so I can't speak to the specific reasons why they wanted to sell it. All I can tell you is that we wanted to buy it.
So how was this sale was that property put out there for sale, or was there something privately done?
Ms. Janusik, how is that relevant to what we're doing here tonight? Why the business decision was made between the prior owner?
Because the prior owner.
Just a minute,
Go
ma'am.
ahead.
You've already asked if the settlement agreement with the prior owner is binding on the current owner, and council has already indicated to you that it was.
Okay.
Now you're asking the current owner, who's giving the board an update, why the prior owner sold the property. Completely irrelevant.
I wish I would concur.
The prior owner did all the work, got a settlement agreement with the court, with the judge and everything, and then goes and sells it. The
That's
question is why.
completely irrelevant, Ms. Janusik. Please move on.
To you, it's relevant. I don't think it is irrelevant.
Relevant, you can't answer.
This property has numerous wetlands, and what I'm hearing is that trees were already cut down and work was started there. Are there permits? Were permits obtained from the Department of Environmental Protection?
We have proceeded in accordance with all requirements that have been that we're required to proceed, that we're required to comply with at this point.
So the question is, do you have permits from the New Jersey Department of Environmental Protection?
We have proceeded in accordance with all requirements that we are supposed to proceed
Thank you.
with.
Thank you for that broken record comment. Thank you.
Good evening. My name's Frank Derby. I live in Montgomery, but I'm here tonight as the second vice president of Temple Bethel, which is a neighboring landowner to the development. Came here primarily to meet Mr. Kessler and to say hello, and just to remind him and the board that we had a slightly different concern, not to denigrate any concerns about environmental measures, but that the concern was that after years of having that property undeveloped, there's now an opportunity for bad actors to take advantage of that and put us and our other tenants who represent all different faiths at some risk. If you recall, the property used to have an entrance that faced 206, but many years ago we flipped that around for, among other reasons, security purposes. And so now the main entrance to the building actually faces Mr. Kessler's client's property. We just ask that the board and Mr. Kessler and his client keep in mind that there are some very serious security issues, particularly in today's environment. And we hope that's kept in mind, perhaps to the extent of including Hillsborough PD, who's always been a tremendous partner for us as your plans move through the building phase. Thank you. That's it.
Thank you.
I think we've exhausted public.
Nobody left.
Videographer. Okay. Any final comments from the board?
Yeah, I have one.
You know what? First, let me motion to close to the public.
So moved.
Second.
All in favor?
Aye.
Okay.
Mr. Kessler, you mentioned that you were going to do mostly underground work, weather permitting, site work, which I assume would include stormwater and the tie-ins and whatnot. Like, that's all. By the spring. So maybe if you could come back, say in March, April, once that's done, maybe before you start vertical construction, and give us an update on how that went, because that's a pretty sensitive area for the residents.
Sure. So I think we're supposed to come back every 6 months.
6
Is that
months?
the requirement, I believe. Maybe we can time it so that I don't know, because we have to send out.
I think they would like.
May,
I think they would like it this time to come a little early, only because of the time.
Because of the time frame. Yeah, sure.
And it's a key point.
Yeah.
So
I think that's so. Maybe as we move forward with the site work and we get a gauge on where we are, we can schedule that, and I'll work with Mr. Bernstein.
All right, I'd appreciate it.
Sure,
Thanks.
absolutely.
David, do we have a tentative schedule for next year yet?
Not in front of me. It does exist.
I think based on that, we'll try to schedule this application from March, April. Date will clear it with council before we confirm it, but
Sure.
Okay.
Works for us. Thank you.
Okay, perfect. Thank you.
All right, thank you.
We do have something.
Samantha has something.
That's me, okay.
Yes, we have the tentative 2025 meeting schedule in front of us.
His former assistant?
Yes.
Go ahead, boss.
What are we looking for? That's where you lost me.
I will help you.
Yes.
Look at March, April. Counselor?
March 6th, March 13th, April 3rd, April 10th.
April 3rd.
I think that would work.
That's fine. And we'll let you know if we get held up for whatever reason. We'll
Even if you get held up, just come on in on the 3rd and give everybody an update.
That's fine.
Mr. Chairman, we'd ask for a motion to continue the, and I'll put this in quotes, hearing close quote on this application, to Thursday, April 3rd, 2025, at 7 p.m. or soon thereafter, as the matter may be heard without any further notice.
So moved. I'll make that motion.
Thank you. For a second.
I'll second it.
Thank you. Roll call, please.
Mr. Wagner.
Yes.
Mr. Radowitz.
Yes.
Smith.
Yes.
Mr. Vitale.
Yes.
Mr. Depp.
Yes.
Committeeman Lapani.
Yes.
Deputy Mayor Ciccarelli.
Yes.
Vice Chair Peason.
Yes.
Chair Sirachi.
Yes. Okay, thank you.
All right. Thank you,
Mr. Hoff.
Thank you. Thanks for your time. Look forward to seeing you in warmer temperatures, hopefully.
Okay. Michael, how are you doing? Do you want to?
Mr. Chairman, can I ask for a few minutes?
Yeah, well, no, Michael always gets to dictate
Well,
what she's
I
asking.
don't know
So we're gonna pause right now. I'm gonna say for about 10 minutes. We'll say reconvene at 8:25 according to the clock. Okay, we're back in session. Next up is TV LLC, file number 23-PB-02-MSV with time of decision of January 31st of next year. This block 143, lot 24.01 and 25, otherwise known as Valley Road, and 183 Valley Road. The applicant to consolidate two lots, and the house on, I believe, on one of the lots has already been demolished, and is seeking preliminary and final major subdivision approval, see bulk variances and waivers to subdivide approximately 5.483 acres, I would say that's exact, into three single-family lots to be serviced by public sewer and well with a private roadway, driveways, stormwater utilities, and associated improvements on property located in the residential zone. And the EC did a review back in September, and the application was adjourned from our October 10th meeting with notice. And with that, I will turn it over to council.
Great. Thank you so much, Mr. Chairman, members of the board. My name is Erica Edwards. I'm a land use and zoning lawyer here in New Jersey. I'm here tonight on behalf of TV LLC. The chairman has provided an overview of the subject property and the reason that we're here. I'll let the board know that we have one primary witness tonight, our project engineer sitting to my immediate right, Frank Farrell of Grotto Engineering. We also have the applicant, Mr. Vijay Vyas, sitting off to my right here and behind me. He is here if the board has any questions of him, but primarily it's going to be Mr. Farrell doing the testimony. So if we can swear him in, I'll qualify him. And
You swear any testimony you give tonight is going to be the truth, the whole truth, and nothing but the truth?
I do.
And the record, can you state your spelling name?
Frank Farrell, Farrell. Thank you.
very good. Mr. Farrell, would you provide your educational and professional credentials for the board, please?
Absolutely. I have a professional engineering license in the state of New Jersey that's active and current. I received that license in 2014. I'm also a certified municipal engineer as of 2016. I can give you a longer detailed version if you'd like, but that's the short one.
Okay.
Okay, any objections?
Have you testified before
Yes, sir.
this
This-
board or any others?
I've testified before a number of other boards in the state of New Jersey and also in front of your environmental commission back in, was it August? September. I've also appeared in Old Bridge, in Highlands, Hamilton, New Brunswick, Saraville, South Amboy. I'm probably missing one or two in there, but I have appeared before other boards and been accepted.
Thank you.
Thank you.
Okay, hearing no objections, we accept and welcome to Hillsborough.
Thank you. Pleasure to be here. So I'm here tonight to discuss the subdivision known as 183 Valley Road, which is really a street address, block 143, lots 2401 and 25. We're going to take a minute and spend a little bit more time than we might normally looking at the existing property because it's somewhat unusual.
Okay, we're going to mark this A1, and if you could just state the title block.
Sure.
Who the author is?
Yep.
And the date on the application, on the page. We normally mark these one page at a time.
Absolutely. So this first set that I'll be going through is actually the plans that are submitted as part of the application package. These haven't been edited or altered in any way. When I do get to a sheet that has, I'll make note of it. But this is sheet 1 of 11 on a major subdivision plan for TV LLC, 183 Valley Road, block 143, lots 2401 and 25. Prepared by Grotto Engineering Associates, signed by myself, Frank Farrell. The last revised date on this plan is July 10th, 24.
And this will be A1.
A1 is the cover sheet.
Cover sheet. Thank you.
Okay. So rather than jumping right into the zone information, we're going to take a quick look at sheet 2, which I suppose would be A2. Same plan set, sheet 2 of 11. So we are oriented north to our right on this sheet, and the two lots are, again, 2401, with my handy dandy little drawing tool here, is this lot on the lower portion of the screen. It is an existing undersized lot that's just under 1 acre. It's 0.999 acres. The surveyor put that on there. I might have rounded up, but it is slightly undersized, as the minimum is actually 1 acre. And then lot 25 is the other 4.48, nearly 4.5 acres, which is all of the rest of this property there. So the unusualness doesn't just stem from the fact that Lot 25 extends nearly 784 feet into the property away from Valley Road, but these properties are also, if you think of them as one unit, are nearly bisected by Royce Brook tributary, which is that dark gray swath running around the middle of the screen, and then the lighter gray area around that is the DEP. And I'm sorry, it's the FEMA flood hazard area. So the lot is unusually shaped. One of the existing lots is existing undersized, and they're much deeper than they would normally need to be. And as a result, we have to approach this in a way where we can get developable land on this property somehow. So that leads us to while I'm on the existing conditions plan, I'll also note that the property generally slopes in topography from the west to the east if you are west of the stream, and from the east to the west if you're on the other side of the stream. So it goes from Roycefield Road into the Roycefield Brook tributary, or from the areas generally west of the site, across the site and down into the stream. There is also a small isolated wetland on the property that the applicant has already submitted for permits to fill as part of, I believe it's a GP6. We expect to receive that permit soon. We've made final submissions and revisions and been discussing that with the DEP. We don't expect an issue with that. That brings us to sheet 3. Same plan set, same A3. Now this one actually has a slightly different revision date than the others because this is just a subdivision geometry plan. So the revision date on this sheet is April 9th, 2024. So what we're proposing out of the 2 lots in excess of 5.4 acres to create 3 lots. The stream being a significant detractor from the developable portion of that existing lot, 2401, in particular because the stream itself, we're not building houses on the water, and also due to the wetland area and then the borough's stream corridor, it leaves a very small segment of, thank you. The township's stream corridor buffer leaves this very small little trapezoidal area out near Roycefield Road as potential developable land. So in reconfiguring the lot lines, we are proposing 3 lots in total. So starting from the left or the south, we have proposed lot 2502, which is where, if you're familiar with the site, the existing building was more or less in this area. Then lot 2 is, lot 2503 is a flag lot in shape and extends, the stem of which extends out toward Valley Road. And then the third lot is 240101, which is extending that short lot that was near Roycefield Road deeper into the site and occupying what was previously part of lot 25. The reason for all of this, again, is to create access and developable land on the site, or utilize the developable land on the site, not to create it. So that brings us to sheet 4. A4, where we are depicting 3 single-family homes, a private road, and an easement for the maintenance of that private road and for the purposes of access to those 3 lots, which will now have driveways that connect to that private road, which then itself connects out to Valley Road. I'm going to pause here about just describing the lots, and I'm going to point out that there's a couple of variances associated with the application and in the lot configuration, lot sizes, and whatnot. So the minimum lot size for the zone is 1 acre. However, when you have a flag lot configuration, the minimum becomes 3 acres. When you have a well, I haven't discussed utilities, but I think it was in the opening. We were proposing wells on each of these lots. There's an existing well there that is was in good working condition. We expect to find that the other wells will have no issues. The minimum lot size goes up from 1 acre to 2 acres, and as a result, we have a lot size or a lot area variance for lot 2502, which is the lot in the front, which is 1.24 acres. So it exceeds the minimum for the zone unless you have a well. Then the middle lot is 2503. It's just 1.99 acres, which is just shy of the 2 acre requirement for lots with well water, and it is nearly an acre. It's a little more than an acre shy when you have the flag lot configuration. The other variance I'm going to point out here is front yard or lot width at the front yard line, and that occurs, I think you can see that, I think it's a red line. I'm a little bit colorblind, but it's at that line on Roycefield Road, which is not a condition that we're creating as part of this subdivision. It's just the existing lot, the shape of the lot dictates that that is and will remain a lot width variance. There was a 1, 2, 3, 4. There's a 5th variance noted in your planner's letter that describes Mr. Coyce's letter that describes access from I believe from a driveway. Let me refer to that. No principal use shall be served from one access drive. If we need that variance, we are requesting it. I'm not sure that when we have a private roadway, it counts as a driveway. My interpretation of that 3 accesses or more than 1 access from 1 access point wouldn't necessarily be transferable to a road, which is what we're proposing. But if that is the board's determination, we would request that variance be granted as well. Speaking of the road, we'll stick on that for a second. The road is proposed to be 20 feet wide and is conforming with the RSIS standards for a rural lane. Actually, it exceeds the standard for a rural lane, which I believe is 18 feet in width. So at 20 feet in width and with the hammerhead configuration that I'll identify here, we meet the requirements for access as a rural lane if this were to be dedicated to the town, which it's not, again, private road, but it meets the requirement. And it also meets the configuration required for a fire truck as submitted to us, your fire department submitted a number of details that were acceptable for the truck turnaround, and we picked from one amongst those, and we designed the turnaround area based on that detail. So that brings us to the actual lots themselves. We have driveways that extend from that road into each of those lots. I'll just note them here. This is sort of a continuation of the end. And these three homes, which we are showing, the two toward the rear, I'll say 2503 and 240101, are both 1,500 square foot proposed dwellings. The total impervious coverage on them is compliant with the zone. There's a note that proposed lot 2503, which is that lot in the middle, which would be associated with that dwelling there, is 14.9% impervious coverage proposed, whereas 15% is permitted, which is compliant. And it's noted that there may be some difficulty if some future owner would want to expand on that. We would indicate that if somebody wants to request a variance at some future date, they're welcome to, but this plan works within the square footage and within the impervious coverage that we're allowed. It also, a majority of that impervious coverage stems from the fact that we have a private road, which is technically on that lot. If we were to consider that road to be its own separate lot, or if it were to be dedicated or a similar occurrence, the lot itself would have a substantially less impervious cover. But be that as it may, we're just indicating what the facts are. It's 14.9%, whereas 15% is allowable. The remaining lot configuration is compliant with the zone as far as setbacks. I can run through those very quickly. We have the minimum lot width at the setback. I mentioned the variance for 240101 is 107.28 feet, whereas 150 feet is required. 2502 has a width of 216.85 feet, whereas 150 is necessary or required. And lot 2503 has 269 feet, whereas 150 is required. For the yard setbacks, we note there is a 50-foot requirement, and due to the nature of this lot in the back here, this 240101, the front setback is actually like more than 400 feet. But the other two lots are 83 feet and 63.6 feet. When we're measuring that relative to, we can consider this house may experience this dimension as a front lot, if we consider that it's actually connected to Valley Road, it goes up considerably, but we're trying to be conservative with our measurements in that regard. For the rear yards, 40 feet minimum is required, 47 for lot 2401 is proposed, and then in excess of 150 feet is proposed for the other two lots. Side yards are compliant with the zone, 30 feet is the minimum, and they are all in excess of 40 feet. The units per acre is 0.85 units per acre, and each of these lots is 0.47, 0.81, or 0.50 units per acre. I mentioned maximum impervious coverage is in the zone and the allowable requirement for the zone. And then the maximum building height in stories is 2.5 stories or 35 feet. And while we're not presenting architecturals at this time, the intention is to provide dwellings that comply with those requirements. So we have, I believe this is are we on A5? Look at my own drawing number here. Yes, A5, which is the grading and drainage plan. The grading for this site, again, is primarily from west to east in the developed portion, which we're talking about, which is to the west of the tributary. And as a result, we are capturing the runoff that would come off of the roadway, and through grading and the use of bioretention basins, we are proposing 4 total stormwater management features. There's one here which collects a majority of the stormwater from the private road. There's a second basin here which captures the runoff from various yard areas associated with lot 2502. There is a third basin on lot 2503, which captures a portion of the runoff that would otherwise bypass the narrow, long roadside swale and captures that before it ends up in the stream. And then the last one is this smaller one back here on 240101. So each lot, more or less, each feature, so the road being one feature and then each of the three dwelling units sort of each have their own stormwater management system. And this was a challenging site to make this work. There's a difficulty in locating these features anywhere else because water tends to like to go downhill. And as a result, we have these features located no nearer to the stream than is absolutely necessary, but we also needed to make sure that they were going to capture the runoff from the areas that they needed to in order to provide the mitigative effects that they are intended to provide. And in that regard, we believe we are compliant with the DEP's latest standards and the township standards for stormwater management. That includes the green infrastructure BMPs and because we have bioretention basins, they're small drainage areas. They have they're not just regular open detention basin. There's going to be vegetation in there that assists in treating and managing that stormwater before discharging it downstream. Staying on stormwater for a second, Mr. Mayhew's letter indicated a number of comments regarding stormwater management, and we intend to provide the information necessary to satisfy Mr. Mayhew in the event that you choose to act favorably on this application. Just wanted to get through the site plan, or it's not a site plan, the subdivision portion of this first before we initiated a substantial amount of additional field work, including soil testing and locating additional trees, which we'll get to in a minute. But the proposed limited disturbance for this is as narrow as we could make it. It's still in excess of an acre. As a result, we are a major development, and we comply with the various features that I'm documenting here with the ordinance requirements. We also, I mentioned, have a DEP application for that wetland, and I'm sure that they would have raised an issue at that point too if they had a concern regarding stormwater management. Sure. The next sheet here is A6, is the utility plan associated with this set. This sheet is also dated April 9th, 2024. The utilities on this site are public sewer and 3 private wells. The sewer will run down the private driveway, and the easement associated with the driveway and access we imagine will also extend to the improvements underneath it, so there will be a shared maintenance of that sewer system. And the wells, again, the wells are provided. We have them here. They're small dots because wells are not very big. But there is a well here. There is a proposed well back here. As tentative locations, ultimately this will be approved. The locations, everything would be approved by the health department and the other entities that have jurisdiction over that. But we also made sure to space them out appropriately based on the requirements in your ordinance. We don't meet the lot size again. We're asking for a variance for the lot size, but we do maintain the minimum spacing required for these wells, which we believe is important so that we don't have any issues as people live there and utilize them. That about sums up the utilities. There isn't a lot more here. It's 3 single-family homes. It's sewer and water to get them up and running. Any other utilities would be installed underground as is typical, whether it be electric or gas. We're going to skip the drainage area plan. This was submitted. If we need to refer to it, it would be, I guess, A7. This documents really what those basins are, the elevations of those basins, the different plantings that occur within those basins, because they're more specific than just you throw some grass on the ground and move on. But they are designed in accordance with the Department of Environmental Protection's best management practices for bioretention basins. We also have a soil erosion sediment control plan already, and we've received plan certification from the district. Yes, thank you. A8. All right. I'm going so that we don't have to just log sheets that I don't intend to talk about. I believe the rate. There we go. All right. So the remainder of this set is the details. So we're just going to stick to what needs to be stuck to. So I mentioned the wetlands permit. We also have the soil erosion certification. We're water service through the wells. We have a will serve letter from the Hillsborough Municipal Utilities Authority. I believe that was submitted as part of one of our back and forths with the planning department. The stream corridor is an important thing to touch on here, and that actually brings me to, are we on A9, I believe? All right, A9. So the stream corridor is an area that is 150 feet from the top of bank associated with a stream or similar water body, and or inclusive of steep sloped wetlands and other similar regulated features that abut that 150 foot buffer. So on this sheet, I've changed the color of the stream buffer line to be pink. So the required buffer is 150 feet from that dark feature that is, again, the Royce Brook tributary. And then the various other colors are, I'll explain them as we go here. So the basin for 2503 encroaches on the stream buffer, but no more than 75.6 feet. And as a result, we're proposing that the buffer in that location be averaged with the buffer on the opposite side of the tributary, such that if we're encroaching by 74.4 feet on the west side of the stream, we're going to dedicate additional land or compensate with that by 74.4 feet, which is actually a greater total area. The encroaching area, if I zoom in on this, is 7,464 square feet. Is that red shaded, I'll see if I get these both on the screen at the same time. There we go. That red shaded area is 7,464 square feet. And the stream corridor compensation in green on the opposite side is 7,610. And not only that, we were going to offer a bonus, as was indicated by Mr. Coyce's letter. There was a recommendation that we consider putting the entirety of the lot that fronts on Roycefield Road, or at least this portion of it, into conservation easement. And we would be agreeable to doing that, which benefits the stream corridor buffer and the conservation easement area on the site by an additional 667 square feet. So if we just used the averaging, which is permitted by the ordinance, we would be compliant and in excess of the area that we are disturbing or encroaching on that by a little over 100 square feet. But we have about 700 or 760 square feet of total compensation provided as part of this plan. Also, if we were, and I don't believe that we need a waiver, but of the things that would be permitted to encroach in this area, basins and their outfalls are specifically noted as one of the allowable conditions that you could receive a waiver for. Again, I don't think we need a waiver. I believe that if the board were to accept the averaging plan that we're presenting, we are more than compliant with the stream corridor buffer. I think I've touched on most of the bigger items in any of the letters. I've certainly identified the variances. I believe that the variances regarding lot size and shape are precipitate from this very unusually shaped and regulated piece of property. And we are making the best use of the developable portion of the site that can be made. If you'd like me to go through the letters, I don't intend to go through them in their entirety. I took the liberty of speaking with Mr. Mayhew yesterday and earlier today, actually, to make sure that we were on the same page coming into this meeting, and I believe that we can generally comply with the statements or the requests made in his letter. I'm going to point out one or two of them that I think we slightly differ on. One is that there's a a recommendation that we provide a parking lane or similar feature related to that private roadway. We submit that the driveways and the dwellings that are proposed have sufficient parking for the units for the dwellings themselves, and that we wouldn't necessarily encourage parking along that private roadway. It also doesn't benefit the stormwater management and other regulated issues or other issues associated with this development, wherein making the road wider would mean more impervious coverage, which would mean more bigger basins and whatnot. And we'd rather not. We'd rather the people who live here park in their driveways and not make use of that as a public, or it's not public, but a parking area. The other one was we intend to provide additional information regarding the flood hazard area that's identified on the site per FEMA. I did look at that, and we are well over 6 feet above the FEMA elevation. And even if you do the adjustment based on the DEP's current inland flood protection rules for fluvial water bodies, which only requires a 3-foot adjustment, we're like double the elevation, and as a result, there's no issue here with the floodplain. We're not in the floodplain, we're not encroaching on the floodplain, we don't need a Flood Hazard Area Control Act permit. The DEP who's reviewing this for wetlands isn't making us get a flood hazard permit as part of any of that application either. They're satisfied with the explanation that we've provided. And we believe that we can provide additional information to the satisfaction of the board and your engineer. I think that about rounds it out. If I've missed something, I'm sure somebody will let me know.
Okay, Mr. Mayhew.
Thank you, Mr. Chairman. I want to commend Mr. Farrell for an excellent exhibit on the stream corridor impacts. If we could only get all the applicants to do something like that, I think it would help out. Mr. Farrell and I had spoke about this specific topic. I'll refer you to our review letter dated December 2nd on the page 6. We had 3 comments on the stream corridor. Mr. Farrell, in my opinion, has demonstrated that his corridor averaging plan would meet the intent of the ordinance, and it would alleviate the need for the waiver as pointed out in item 3. So it would eliminate comment number 3. As I understand, Mr. Farrell has testified that he'll meet the engineering detail comments as far as stormwater management and utility and grading, and our office believes that those items can be addressed. So I just want to talk about a couple other items on the review letter. Under page 2, general comments, Mr. Farrell talked about the parking lane. Certainly the plan as submitted with a 20-foot wide cartway in a 40-foot easement meets the geometry requested in RSIS for a rural lane, which requires that there be less than 200 average daily trips, which certainly 3 lots would produce less than that. So it does meet RSIS. Our office would defer to the board whether they feel there's any potential future parking issues or whether the parking can be provided on lot. We take no exception to either way. I agree with Mr. Farrell that looking at the plane elevations, it appears that the site is out of the New Jersey Flood Hazard Area Design Flood, but we've agreed that it should be noted on the plan just to document that the work is outside that area. We're not requesting that he go get approval from the DEP. We just want to see the line on the plan. If you turn to page 5, under traffic comments, number 1, I understand Mr. Farrell has received the detail from the fire department as to an appropriate K-turn, but our office would just like to make sure the turning movement is shown on the plan and any potential easements that might be required will capture that truck making the turn.
Sure.
And I believe you've agreed to add that.
We can certainly provide that auto turn detail.
And then under item 2, we would like to see appropriate information on Valley Road, making sure there's appropriate sight lines coming out of this private drive. It is a busy road, and I believe I don't know if you testified, but if you can now, you're agreeing that you will provide that information.
I believe it is reasonable. It's a reasonable request, and we'll provide information to your satisfaction.
Okay, good. That addresses all of our comments, Mr. Chairman. I'll leave and defer to Mr. Coyce to give him the thunder. We agree there are 5 variances, and they've been discussed, but maybe Mr. Coyce wants to elaborate on some of them.
Thank you for the opportunity to bring the thunder. That was quite an introduction. Mr. Farrell, again, thank you. I'll try to live up to it. Mr. Farrell, thank you for, and for the applicant to take in consideration all of our comments, especially with Roycefield Road and the averaging of the stream corridor. So we certainly appreciate it. My only concern in one of my comments was the proposed impervious coverage going basically almost to the max limit at 14.9%. So the concern from my office is just because of history here in town. We have other applications in which the dwellings were built basically max capacity, and then in the future it's led to the future homeowners, who were not the applicants to build the house, to then come to the Board of Adjustment to ask for relief of variances and things like that. So one of the asks, is there any consideration to try to reduce the size of the dwelling? Because otherwise, essentially, what is happening with the proposal is this proposal, if granted, could eliminate any argument that a future owner could have in trying to seek relief for a C-bulk variance for impervious coverage as a self-imposed hardship. While that might not be the current applicant's issue, the thought is there any solution to try to propose a dwelling size so that there could be future impervious coverage? Because right now I think there's about 59 square feet left, and even someone trying to come in and putting a 100 square foot shed, which they're not usually 100 square feet, to be honest with you. So
I believe that the application as we've submitted complies with the ordinance, and that up to a building up to about 1,500 square feet would be appropriate on the site, based on the fact that really it's the private roadway that kind of does that lot in, if you will, for lack of a better phrase. But it's compliant. And the amenity on this site, I believe that I haven't checked today, but are decks and pools considered impervious coverage as part of the application?
Yes. The pool surface itself hasn't been. That might not always be the case
coping or
in the
hardscaping
future.
around it, maybe.
Yes.
All right. I believe that this application complies with the requirement of the zone, and if there's an owner that wishes to purchase this with the idea to expand on it, that they would have to do their own due diligence regarding their ability to do that in the future. I don't really see a way to, unless you want us to ask for a variance now, which we didn't think was really necessary. But the other 2 lots, ultimately, I believe it comes down to the applicant, their ability to market this property and to be responsible to themselves and to the purchaser. If they want to build a smaller house and have more amenity space outside that might be hardscaped, then that would be a choice that they make when they choose to do that.
I agree with you that the board cannot ask you to or even grant a variance if you're not going over the 15%. I definitely agree with you there. And up for the board's consideration, and also for the applicant to consider, possibly a possible deed notice, just bringing to the future purchasers awareness of the house going to the 14.9%. I will defer to the board. Again, just bringing this up with experience and issues that unfortunately we have seen here in town, because the township, while there is a maximum impervious coverage, we don't generally in our residential zones have a max limit for the building itself, which would have automatically created some wiggle room for other improvements. So I will leave that to the board for their consideration. I've nothing else to add.
I'll also point out that as far as impervious coverage goes, I mentioned that the minimum width for a rural lane in RSIS is, I believe, 18 feet, but we're proposing a 20-foot wide road. That's not because we wanted a wider road. I'd love to have saved on impervious coverage and been able to distribute that in some other way around the site. The fire department requested specifically the pavement width being 20 feet to accommodate the apparatus that may be used to fight a fire in an involved structure at this location. I'd love to save 2 feet off the whole length of the road, but I don't know that we can, and also comply with the fire department's request for that width.
Mr. Chairman, how the discussion was going on with Mr. Coyce, I was taking a look at the plan, and that idea came to me as well. 'Cause certainly 18 foot is the required width according to RSIS, and it allows up to 200 trips a day. With 3 homes, we're going to be less than 60 trips, 50 trips a day. It's very minor. So I wonder, and I don't ever want to contradict the chief, but in this case, I wonder if the board would consider maybe decreasing the access road to 18 feet wide within the back half of the property, which is along the lot number 2503. So we leave 20 foot wide at the front, but then downsize it to 18 feet wide beginning at lot 2503, conditioned upon that our office would discuss this with the fire chief to make sure he's comfortable with it. That would produce 400
a significant
that would
reduction.
produce 400 square feet of impervious cover that could be banked for future homeowners and maybe help make Mr. Coyce's office, give you some breathing room, maybe.
Could I, that turnaround that you have there for the trucks, does it make sense, again, to save impervious for this lot that's getting screwed, so to speak, make the driveway for the second house share some of that impervious, so move that T over to the existing driveway, and that becomes now a shared driveway that is used as the turnaround.
Right. Could you pull that up?
I think that's
the impervious, so we can reference that.
That's an excellent insight there. I wish I thought of it actually before we got here.
I'm a dirt guy.
It's good. No, it's good. Okay, this sheet, which we're going to refer to, let me go back. This one's A4, sheet 4. If I can crudely draw, I believe what you're describing is take this T and basically put that here, so that this home ends up with a significant
or more to the left,
or
so
further that way.
Yeah, so it's
Between the 2 buildings. Right at the property line. The other gray.
Right there.
Over here. Okay.
And while you're doing that, Mr. Farrell, I'll just interject. So everything in gray is impervious?
No. I'm sorry.
Please clarify that.
I didn't mean to cut you off, but no. The gray associated with the dwellings is just to note a small rectangle on an otherwise on a sheet with a lot of other lines on it. That's the dwelling. That's these areas here. This shaded area corresponds with the easement area, which is shown on A3. I'll get rid of the other lines on this sheet. No, I won't. Okay. But that gray area is the easement area. The impervious coverage is not on this plan highlighted or identified in any specific color or shading, but it's more limited to this area here where we have the 20-foot wide road. At least as far as the easement is concerned, this is all impervious in here, in that otherwise larger gray shaded area.
So if I want to understand, Mr. Lapani, you wanted to look at moving the K-turn and share it with the lot 24.0101.
Oh, we could share the impervious, the burden of the impervious coverage with the lot that doesn't necessarily have an issue
Well,
with impervious coverage.
I'm not sure if the chief wanted the road turnaround at the end for convenience sake, or anywhere we can move that to share the impervious with another
With
lot.
another lot,
or
yeah.
Or that driveway. So the driveway at that, I'll call the middle house.
Yeah.
You butt it right next to the side of it.
Put it sort of over here.
Right.
Or I believe your other suggestion is sort of do this with it.
Either way.
Such that
So
impervious coverage
you're
ends up
giving
on another
relief
lot.
of impervious to that center
Sure.
lot, because that person's going to want to have a patio and a walkway, and well, God forbid we would have to have them in front of our Board of Adjustment in 6 months. So I know you and
we'll work
and
out
our
a solution.
engineering can figure out maybe the best alternative to place that to give that middle lot some relief of impervious. And as far as the reduction of from 20 to 18, I don't think that's going to affect how many fire trucks can make it in and out of that.
It's still going to be
driveway.
one. You're not going to put them side by side. So.
Yeah, but I think if we move the turnaround and that's part of a relief there, yeah, I think that would help. I don't know, Mark, if you think that's.
I think moving it north, because I'm sure the chief wants to keep it at the end. So moving it north and sharing it with lot 240101 would be the logical location. Frank, if you want to sketch that again.
Yeah.
Because that's the bigger lot too. That's got like 2% impervious.
Yeah.
Correct.
It's hard to draw.
It's at 3.7.
Right.
So it has a lot of
available land.
Yes.
We can move it either all the way in. We can move it all the way into that lot or more into that lot.
Probably for the chief makes sense because that gives them the ability to get all the way in with their apparatus.
Mm-hmm.
I might suggest moving the house a little farther away from the turn.
There's going to be a couple things we got to look at when we make that adjustment. Sure.
Could you not put that easement with the end lot? I mean, you have one flag lot. You actually have two flag lots.
We have one flag lot. The other one happens to share access.
Oh, because it has
because it technically it connects out to Roycefield.
Right. But you can't associate.
Experientially, it's going to feel a little bit like a flag lot because you're going to drive down the shared driveway.
Right, but what I'm asking is, why not? What's the last one? Is it 01?
0101.
Can you put the lane with that lot instead of the middle lot? No, you don't have to do anything. It's just where which piece of property it's associated with.
Yeah, that's what we're talking about.
I don't know that I understand. I'm not sure that I understand.
Instead of this being associated with this lot.
Here, let me zoom in and then you can point better.
I can't reach it. I'm not.
Yeah, let me get that a little lower for you. Hold on. There you go.
Instead of this being associated with this lot, it's associated with this lot. The whole thing.
Well, it's an easement.
Oh, it's okay. So if we read,
it would no longer have frontage, that lot.
Yeah.
Right. So I wasn't sure if that's what the problem would be. So the middle lot, 2503, achieves frontage and it meets the ordinance requirement of a 25-foot pole out on Valley Road. The end or the farthest rear lot meets frontage criteria because it has frontage on Roycefield.
Down here.
Right.
Zoom out so we're not making us all dizzy.
Okay. I think you get the biggest bang by just moving the fire K-turn completely on to the rear lot because there's so much, as you said, Sean, so much additional land on that lot.
Okay.
Ultimately, it won't be a variance condition, but I believe what we're discussing is we'll agree to modify the K-turn area such that we provide, even though we're not requesting a variance for impervious coverage, but less impervious coverage on that middle lot 2503.
And would it be the board's desire if the fire chief was amenable? Because from an engineering standpoint and RSI standpoint, that lane could be decreased to 18 feet wide, and that would pick up additional impervious.
I think it would make sense.
Mark, can you Mr. Farrell, I should know that my wife's maiden name. Can you describe how, being that we're now doing all these new storm regs, how that triggers in with all these BMPs and the basins that are being proposed? I don't know if there's infiltration planned here as well as holding capacity and release.
Sure.
Because I'm sure that will come up in the public because it's
the stormwater management design for this site complies with the current DEP standards, which were revised in 2021. Not the fluvial was 23. The current DEP standards for stormwater management for major developments. That includes the calculation of both the existing and proposed flows for today's 210 and 100-year storms and the projected or future values for the same events in the year, it's roughly the year 2100. So not only are we calculating stormwater management for the 210 and 100-year storm as they exist today, we're calculating those same things for 100 years from now. The BMP and the DEP stormwater management regulations under NJAC 7.8 both identify a number of ways to satisfy the requirements. One of them, and there's actually a tiered list of tables, but one of them in one of the preferred, I'll say, methods is small-scale bioretention systems that treat stormwater relatively close to the source that they are receiving runoff from. So the reason we don't have one big basin, even though making one big basin and one outfall is generally more cost-effective, is there's a maximum contributory drainage area for those basins, which is the land that sheds water in to such a basin, is capped. We're well under that cap. We also have, again, multiple. So each dwelling roughly has its own little stormwater management system. Bioretention systems, the way they tend to function is we design that for the water quality storm, which is the first event. I mentioned the 210 and 100, but there's also the water quality storm. That water quality storm generates 1.25 inches of rain in about 2 hours, and that typically picks up all the sticks, the dirt, the oils and whatnot that might come off a road surface, which is the primary pollutant contributor for that the DEP considers. It's regulated motor vehicle surface. The vegetation in these systems is actually engineered. Again, it's not just grass seed. There's a specific list of plantings that are preferred for these basins that we're providing. In addition, the outfalls or the orifice, the outlet control structures that stop or store or slow down water from leaving the site are also designed in accordance with those standards. So for the water quality storm, the requirement is that we recharge the whole thing. That before we let any other water out of the basin, the elevation of the water quality storm is calculated first. And then we start from there. We start at 0 for the 210 and 100. And each of the 4 of these systems all were calculated with the current, the projected, the water quality, all of the other requirements that would be required under those rules. Recharge is one that comes up as I don't believe it's actually required, but nonetheless we're providing it. Typically when you're deforesting a large area, and I don't mean taking down several trees on a site, I mean actually deforesting, removing woody vegetation and whatnot, is typically the time at which the DEP looks at the more significant recharge requirements for a site such as this. Nonetheless, again, we are recharging at least the water quality storm because we don't have a way to let water out until that storm is passed through. If there's another facet to that you'd like me to expand upon, I'd be happy to.
No, I just that you're providing all that. You got tension, recharge.
It's designed so the county controls the bridge that's just down. It's just off this sheet. The county had a similar request to provide additional stormwater management information, very similar to Mr. Mayhew's comments, and we intend to satisfy theirs in the same manner. We're going to have to do the same work to satisfy both agencies that the system that we've designed and will construct is adequate and appropriate and meets the regulations.
And I didn't see in your list of plans here, maybe I missed it, any of the tree mitigation for trees taken down and being replaced on site?
We requested, I believe, like a partial waiver or a timing waiver from that requirement. We intend to provide the list of trees to be removed and the replacement trees to the satisfaction of the board and your engineer and planner. the expense associated with going out to identify those trees and whatnot is something we prefer to defer to a point where we can for that as resolution compliance if the board does choose to act favorably.
How do we monitor that when they tag them and we go?
We can provide a tree inventory plan that would identify the trees on the site. We would then cross-reference that with the limited disturbance that we have, and note which trees are to be removed, at which point we can do the calculation for the replacement trees that would be required under the ordinance.
And that's provided before you take the trees down so we can verify that?
It would be provided at the time that you're required to provide it.
We would suggest to the board to make it a condition of approval that this mitigation plan is prepared and available for our office to review and approve prior to signing the plans.
100%.
And just clarification. Just turn that on. Just for clarification, is it the intent that the applicant would be able to comply with the mitigation requirements in terms of the ratio for replacement?
I believe so, yes.
Okay.
And if we would need a variance, I imagine we'd be required to come back to the board.
Thank you. Just clarification. Right.
If we were going to ask for a variance, we'd be doing it now.
I just wanted to make it clear because Mr. Mayhew and I won't have any jurisdiction to, if you were to try to ask for something.
Right. We can't. I can't ask Mr. Mayhew or you for a variance in 3 weeks. The intent here is to provide attractive homes and properties for somebody to purchase, and I believe that the landscaping goes hand in hand with that. There's a natural stream to the rear of the property that I believe is an attractive feature for somebody that wants to be relatively close to nature and to not have nobody's going to build in that stream, right? So that becomes an attractive feature. And also screening between the neighbors. We intend to provide landscaping so that the neighbors aren't walking out the front door staring at each other. Something that you'd want to find and you'd want to live in, right? You're going to buy a nearly 2-acre piece of property. We want it to look like it.
I have a question about the roadway and the RSIS. I guess if you could just, I don't know too much about RSIS. Can you explain to me the regulations for the rural road? Like, Mr. Mayhew, you mentioned about the traffic. Like, what's the exact calculation to make it qualify for a rural road?
The qualifications for a rural road are traffic not exceeding, I think it's a range of 200 to 500 trips per day, as calculated based on available industry standard trip generation rates. And that's typically, how often do you leave your home, right? You leave your home in the morning to go to work, you come back at night, you go out shopping. So they've averaged that into a calculation that you can do. And for 3 homes, it's nowhere near 200 trips per day. I haven't done the calculation, but my experience tells me that we're not even close. So there's a hierarchy of roads in the RSIS, or the Residential Site Improvement Standards, that dictates features like roads and other residential development all across the state of New Jersey. Doesn't matter what the local ordinance is, it does. But if you conflict with RSIS, you're actually required to comply with RSIS first, or identify that you're requesting a waiver from it. To that end, there are, again, a hierarchy of streets. There's rural roads, there's alleyways, there's residential roads, there's collector, arterial, major arterial, all the way up through 287, right? Interstate highways. Of those types of roads, the rural lane is one of the smaller, narrower, less trafficked one. Again, between 200 and 500 trips a day is before a road would be classified as one of the higher tiered or classifications of roadway. And each of those in the RSIS, if you were to look at a table, comes with its own minimum cartway width and associated average daily traffic. It also provides recommendations regarding road width if you were to provide parking. And suffice it to say, this actually slightly exceeds the minimum requirement for the rural lane in that it is 20 feet wide rather than 18. The RSIS also provides details for how thick that pavement cross-section should be. And actually, I believe the fire department also provided a minimum pavement thickness so that they would be able to drive a fire truck down it, because we're not just talking about passenger vehicles. We want to make sure that an ambulance, a fire truck, a garbage truck, et cetera, can all access these properties through that roadway. And it's been designed, and the details would confirm that that is the case, that it complies with RSIS and other applicable standards.
Got it. No, I appreciate that.
Sure.
Is the reason it's a rural road, is it have anything to do with its location? Or
No.
Not at all?
Nope. If you were to put that road in the middle of New York City and
just
found
because
some
it's
way
private.
to make sure that there were only 200, only 200 or no more than 200 trips on it, it's more a classification of how it's used, not where it is.
Got it. Thank you. I appreciate that. And my second question about the road is the parking, that there's no parking considered on this road, right? There's no parking lane that's going to be
correct
adhered to. Does RSIS require any sort of signage saying that there is no parking?
I don't. Traffic signage gets into the MUTCD, the manual on uniform traffic control devices, and also the local police department also has, it's Title 40, has a significant leeway in how they would control what would be public rights of way, which is not this. As it's a private road, I believe the onus would be on the owner to make sure that the road is maintained and signed in a manner appropriate for the site. That said, if all of these homeowners are living there and there's an agreement, there's going to have to be an easement and an agreement as to how they all own and maintain the road. They all got to play nice. So if they also all have parking on their own segments of the driveways. So I don't believe that parking along the road becomes an issue. If we wanted to add signage, we could. But I don't believe that really lends itself to, maybe we put a sign that says, private road, no parking, no public parking. But
Well, Frank, can we agree now that there should be at least one sign facing each way that says no parking?
Sure. We can put a sign up that says private road, no parking, or no parking, anytime.
Okay. Thank you.
Quick question, any reason why wells and not public water?
Public water is apparently very expensive at this location. Is it New Jersey American?
Yeah, and they have an easement also.
I'm sorry?
On the certified list, they says there's an easement, so it doesn't mean there's water running through, but
right. So
they have rights to.
So to extend the water main down, I'll say about 650 feet would be prohibitively expensive relative to the improvements that we're proposing. We're not providing a water main that's going to satisfy 6, 8, 10, 12 dwellings. It's 3. So adding tens of thousands, if not hundreds of thousands of dollars, or about $100,000 to each property, it's just not feasible. It's not practicable.
Mr. Chairman, if I may, for the board's edification, the Board of Health and the Health Department have regulations on the books that if for some reason these wells are not able to perform, they would be required to tie in the future. So just know that there is that safety net.
Mr. Farrell, does your impervious calculation, how does it currently treat the driveways?
Impervious.
As impervious?
Correct.
So it's included in there?
Yes.
Okay.
Anything that would reasonably be considered impervious coverage, including roadways, buildings. We're not proposing a lot of sidewalk or anything else, but anything that you would probably reasonably think is impervious has been calculated in that number.
Okay, it's not stone, or
we're not proposing.
That's why I'm saying it's not. It's in the calculation, which is fine.
It's in
not
the calculation.
That's
if we pulled the paved driveways out and made them stone, that would also reduce the impervious coverage.
That's why I'm asking. I didn't know if that's how it was calculated, but it's not. So you were more conservative.
Exactly.
Yeah. Okay. How about the stormwater management features and maintenance of those?
Mm-hmm.
Is that up to each individual property owner, or do you?
I believe that it's going to be a requirement of the group of homes as a maintenance agreement to maintain all of the structures because of the way that in part the DEP rules are written regarding systems like this. So when you have a major development, you're not allowed to just say, hey, you homeowner, let's say we had 10 lots, right? And you build 9 of them are homes and one of them becomes a stormwater management basin, or one of them has a basin on it, you can't just tell that homeowner that they have to maintain it. The requirement from the DEP is that we provide a maintenance plan that would identify the group of homes as responsible for maintaining that, but that's not uncommon for this this development anyway. We already have that situation with the with the road and with the sewer out on the.
The Environmental Commission asked about it, so I'm kind of asking just to clarify what.
Correct. The maintenance of it would be as a maintenance agreement shared amongst the homeowners.
And so that kind of leads to another question, and this might not be for you, but what else would fall under that purview? Is there an HOA? I mean, you talked about garbage removal. There's going to be recycling, maintenance of the road as needed, and snow removal. So what? I don't know what else. Is there an HOA? That's I guess again probably not yours, but what other things would fall under that?
I believe that it would fall under a general maintenance agreement. Would be the applicant's preference. We did discuss that briefly before our hearing today. I think reasonably you've touched on most of it. It would be the sewer, the road, the maintenance of the stormwater management basins. Thank you. Potentially garbage removal. I'm not sure that would be required to be under the maintenance agreement. I imagine each homeowner could find a way to have their garbage.
Well, you might have 3 trucks driving up the driveway instead of 1.
They should start talking to each other and figuring out that we should consolidate this, because why are we all paying for a truck?
Exactly. They'll figure it out.
But I'm not aware of anything else that would be required to be in such an agreement. But we've just named about 4 or 6 things that would make a lot of sense in there.
I think the maintenance agreement for the detention basins would have to be applied to the township so that we can make sure that they're taken care of.
Yeah, that's also in either the standards for DEP, or I'm sure there's an ordinance requirement you have for it. But we would supply an operation and maintenance manual and whatnot associated with these features as well. I believe actually that was probably in the stormwater management comments that we kind of breezed over earlier.
So just kind of getting to the whole concept of an HOA, does that need to be defined as part of whether the resolution or part of the deeds?
It would have to be a condition of the resolution.
Okay.
Condition of approval that the parties, that there be a homeowners association, that the documents be provided to the township for our office's review as well as the applicable township department, and all parties would have to enter into it, and it would have to be reported.
Okay.
As part of the deed.
If I may, also in our ordinance, we have it laid out, Chapter 18855, Homeowners Association, and how it functions and everything like that. My understanding is it's typically required.
All right. So do we have?
When it involves basins and maintenance.
We have to state that as part of the resolution. It's required, because I'm just looking at the community impact statement. It was very vague in saying, just covered the private roadway and just said it may be maintained by the applicant or another private entity. So I'm just looking to see that we should get that defined with all the other, I guess, nuances.
I would recommend that it would be included in the resolution so that there's no confusion at all. Usually our in-house engineering department is usually involved in terms of enforcing that and making sure that those agreements are done. But yes, it would be helpful if it's stated in the resolution.
And can I just ask Mr. Bernstein, the resolution ultimately would get filed with the deed related to the subdivision, so it's clearly out there for notice to anybody that might be purchasing this property?
It would be, I would recommend the conditions that there's no dispute by any of the potential homeowners or future homeowners that it's part of the recording of any acquisition of the property.
Right, but also part of the deed for the individual subdivision of the lots. Rather that it gets recorded at that point.
It would have to be at the acquisition and recording of the individual deeds. So the problem is, it's got to be recorded at the time of the filing of the overall deed and the subdivision deeds as well.
Right, that makes sense, so that it puts clear notice to any purchaser of the property of what they're getting into and what their obligations are going to be relative to each individual lot, because it's a huge undertaking for a small development, if you will, for the property owners. So there needs to be clear notice, as well as the impervious surface issue for the properties.
One of the challenges we do experience is the actual organization of the homeowners association itself, because essentially what happens during the development of the lots, the developer, the owner of the property, is essentially acting as the homeowners association up to the point of then selling those properties. And then there's usually a little bit of a challenge in getting the property owners to all do what they're supposed to do, but it's just a function. There's nothing to fix it other than we have the rules in place to enforce it.
And they'll be motivated. Because I know one of the other things that didn't get mentioned was the liability insurance. It's going to be for the common ground, which is the roadway.
Right, and if the township had to maintain anything, it's pro rata. We start to, basically start to charge all the, right.
Is the township under that obligation? Because you don't want to get caught in a trap.
It gets to decide to do it if it wanted to. Per the ordinance, everything's in chapter 18855.
Okay.
So there's enough teeth in there to protect the township.
Okay. And I'm trying to think. Oh, as far as the dwellings, because I know obviously we don't have an architect here, so we don't know what they're going to look like. Is there a plan to have basements?
Yes.
Okay, and then question, Mr. Mayhew, any concerns with water tables?
I'll point out that I believe we're going to do some soil testing as part of the stormwater management requirements, which should give us an indicator of whether those basements are going to be problematic regarding high groundwater or other similar issues.
So then that's got to be, I guess, also part of the resolution, or it'll be up to Mr. Mayhew to make the final call whether or not basements would be allowed based on those results.
We don't know what's in the ground until we don't know what's down there until we start digging holes. But the soils information was favorable for the design, at least.
Okay. Can I give you more to do?
Oh, and I'm also reminded of the fact that the existing dwelling there, which is that one on 2502, does have a basement. That basement's still there. And I don't believe I'm not aware of any issues.
Not, but, yeah.
I'm not aware of any issues that the basement experienced.
Okay. And the last one, Mr. Coyce, is more for you, because I know there's a mention in here in the community impact statement about round 3 affordable housing requirements. Would this application slip into round 4?
They still have a contribution obligation.
Well, according to the cited ordinance, it applies to 5 or more dwellings.
A 5 or more dwelling units require the creation of housing. Less than 5 units require the contribution to the Affordable Housing Trust Fund.
Right.
It does for every development in town, irrespective of size.
Okay.
And just to piggyback on what Mr. Bernstein.
As long as they're not creating affordable housing.
Right, and at the time of CO is when those funds are collected through the building department, then go to finance and back into the Affordable Housing Trust Fund. And the rates for that is stated clearly in the Affordable Housing ordinance.
It's adopted back when the plan was approved by the courts.
Okay. Yeah, I just want to make sure there's clear understanding, because there was a statement in here saying proposed development essentially doesn't, the affordable housing order is not applicable to this application. Right, not general.
To the extent they're not required to build.
Right.
They are required
Required to contribute.
Right.
Okay. Any other questions, comments before?
I have one more, just curiosity question. Where's the nearest fire hydrant?
I believe we're going to end up providing a fire hydrant. Oh, no, wait a minute. There's one. I don't know if I can find it. Yeah, offhand, I don't recall. I believe in my preparation, I saw one. There it is. So it is along the property's southern frontage.
So are you required to provide any additional ones on this site? No?
Yeah, well, the challenge is there's no water going.
Because it's well.
It's well.
Got it.
But with that one fire, is that sitting on the property itself?
No, it's in the right
So
of
that's
way.
going to be a township contribution.
It's on the other side of the road, correct? Yes.
Is it already there? Or is it
Yeah, it exists.
Oh, okay.
It exists. It exists.
Okay, so it doesn't.
It's on the opposite edge of pavement. Or, yeah, it's on the opposite edge of pavement, across the street from the dwelling that was there.
Okay.
Thank you.
That just brings up, so there's a water main out in Valley Road then?
Correct. And despite the fact that there's a water line there, New Jersey American's water's cost to extend that main into the site is very high.
So they're treating this then, the private road, as a need to put a main. Did you discuss just providing service?
I did not have that conversation with them directly.
Certainly, didn't the conversation come up to at least the front lot, tap off the main directly? And
the front lot, well, the existing front lot has a well, which if we could connect, there is an opportunity, I suppose, but that well serves that front lot without issue.
But is there a reason you wouldn't investigate talking to New Jersey American about simply extending services instead of extending a main?
I believe we can have that discussion with them and let you know what the result of that is.
Especially since we're dealing with lots that are under the 2 acre.
Mm-hmm.
We can ask, certainly, but.
If the board desires, I'd like to make sure we get communication from the applicant as to.
Yeah, no, I think that's reasonable to at least have a discussion.
Okay.
Any other comments? Otherwise, I'm going to ask for a motion to open to public.
So moved.
Second.
Okay. All in favor?
Aye.
Aye. If there's anyone from the public that would like to ask this witness any questions of his testimony this evening, please come forward, state your name and address for the record.
Susan Gullo, Fort Hunt Club Road. I have one question on the wells. You have one existing well, and you would be drilling 2 additional wells for the other 2 homes?
That's correct.
Okay. Are there any surrounding properties that are dependent on wells that might be impacted by the 2 new wells that you're aware of?
I don't know. However, the proposed wells are located far enough apart from one another. There's a minimum well spacing requirement in the ordinance, and they meet that requirement. And I believe they would meet that requirement relative to a neighbor's lot, in part because of where they're situated or proposed tentatively to be situated on the site. This would also get reviewed by the Township Health Department to make sure that there's no issues. Any well is going to get reviewed by the Township Health Department, not just these.
And your discussion before on the driveways, is there a impervious coverage percentage on driveways is different for stone versus pavement?
It depends. Most not in Hillsborough. It's all considered impervious? Okay.
I believe you may be referring to how it's treated via stormwater, correct?
Correct.
Okay.
Okay. That was the 2 questions. Thank you.
Maria Janusik, 720 East Freck Avenue, Manville, New Jersey. You mentioned that there is that the Royce Brook tributary is along this property.
It nearly bisects the properties if you consider them one. But yes, the Royce Brook tributary.
And then you mentioned a stream. Is it the same body of water?
I may have used the term stream or brook or tributaries interchangeably throughout my testimony.
Okay, so it's just that one body of water.
Correct.
Okay. Does this application require a letter of interpretation?
We have one, and it's been submitted as part of the application package. We're also expecting a permit for the filling of a small isolated wetland any day. Whenever they.
I'm sorry, permit for what?
There's a small isolated wetland on the property that is going to be filled as part of this development, and we expect to receive that permit soon. If I could make the DEP act sooner, I'd have more jobs, I imagine, but we're expecting it soon. We submitted final documents to them last week or earlier this week.
So what you just mentioned, there's only one wetland. So when this property is divided into 3 separate lots, will there be wetlands on any of these?
Yes, the area along that isn't necessarily water itself along the Rice Brook tributary has also been identified by the environmental consultant hired by the applicant, and the flagging that we're showing. There we go. So this flagging, it's the WA series, is along the west side of the stream, and it identifies so does the LOI, identifies the area as being wetland with a 50-foot transition area that we are not encroaching on or disturbing. So there will be wetland there, and we're not disturbing any of the remaining wetland other than the one that we've submitted for a permit for.
Okay. You mentioned the FEMA hazard area. Why did you mention the FEMA hazard area?
The FEMA, or the Federal Emergency Management Agency, has identified that there is a 100-year floodplain on this property, and we've been just being upfront with all the information, as we always are. We've identified what the limit of that flood hazard area is on the plan. So FEMA has identified that there's a flood hazard area on the site. However, that flood hazard area does not extend into portions of the site on which we're proposing development, and we don't expect, there's no trigger for a permit from that, as we're not disturbing it and we're not proposing development within that flood hazard area.
Okay, thank you. There's an existing house on the property now?
There's the remains of an existing house on the property now. The superstructure has been demolished, but the foundation and basement remains.
How was that house accessed?
Referring to A2, the existing dwelling had access directly onto Valley Road, and rather than proliferating accesses onto Valley Road, we're consolidating by removing that asphalt driveway, and that dwelling will access the private roadway before accessing out onto Valley Road.
Okay. Oh, you mentioned you were asked about basements, and you said you have to first dig and see what's going to be found underground. What do you mean by that? What are possible things that you might find?
Typically, the concern with basements is a high groundwater table that would require sump pumps and additional maintenance and nuisance conditions being created on the site. However, the existing property there, that existing dwelling, does have a basement, and I'm not aware of, and I don't believe the owner is aware of any issues with that basement. We're not expecting to find issues with the other 2 dwellings that we would build. However, I've never been able to look through the ground. So when we do the soil investigation, we will gain new knowledge and information beyond what's been recorded in available soil mapping data. We believe that information will allow us to finalize the stormwater management design, and will support the idea that the basements will be fine on the other 2 dwellings.
Okay, so if is underground water, as long as you don't have a basement, it's okay as far as the building the house on that type of land?
Yes. I believe we're approaching a conversation about how far down do you have to go until you find groundwater. and there can be aquifers anywhere. If you dig a well deep enough, oftentimes you'll find some water. The question is it viable to dig a well deep enough to find the water? Given the proximity to the stream, I would imagine that we wouldn't have to dig excessively deep wells, except deeper wells also provide benefits, that they don't get contaminated with surface water issues. But I don't see it as posing an issue for the construction of these dwellings.
Okay.
That would also be part of the submission to the local building department when they review the foundation design and whatnot at that stage.
Okay. Are all 3 lots undersized?
No. Wait a minute.
Yeah, you require a variance for each lot because they're not the required size?
There is a lot area variance for lot 2502 and 2503, which are the 2 lots to the south or the left. The lot 240101 is compliant at 2.11 acres, where 1 is required normally and 2 is required for the well. However, there is a lot width at setback variance for that lot 240101 at 107.28 feet, whereas 150 feet is required. However, as I pointed out earlier, that variance stems from this area here just being slightly narrower at 107.28 feet, and there's really nothing we can do in the geometry of this to change that feature, to change that fact.
All right. This is considered a major development. I'm not familiar with what is the difference. What would be the requirements if you were just building privately versus being part of a major development?
The major development definition is really more of a stormwater management precipitates out of the stormwater management requirements, wherein a major development in the state of New Jersey under the DEP's regulations and similarly under the Townships ordinance is a development that exceeds an acre of disturbance in total or more than a quarter of an acre or 10,890 square feet of new impervious surface after 2001, or the creation of 10,000 or a quarter acre of motor vehicle surface after 2021. And as a result, the total lot disturbance associated with this application is just over, where am I? Get to that. Give me a minute. The limit of disturbance is 2.78 acres, which exceeds the 1 acre allowable, quote unquote, not allowable, but it triggers the requirements for a major development. There is no minor development. You're either a major or you're not a major. There is no catch-all for if you're not a major. That is to say, if you were not a major, if you didn't disturb more than an acre or a quarter acre of new impervious, you would be left with whatever ordinances the township or other governing body may apply to the development. But it's really a moot point to discuss that issue because we are a major development and we're complying with the requirements for a major development under the states and the township's rule for same.
Thank you. And regarding the wells right now, comments were made about how expensive it would be to tie into the to New Jersey American Water. So if someone were to buy a house, and they have a well, and then there was an issue with that well, they would be required to, what sounds like very prohibitive cost, to have to tie into the water to a water main. Is that the case? It would be this is very expensive right now. If someone were to buy a house and have an issue with the well, they would have to pay that huge cost to tie into a water system.
I'm not sure that that's accurate. I believe that the cost we were discussing as part of providing water service to all of the homes is the extension of a water main. And as part of our conversation this evening, we agreed that we would approach New Jersey American Water with the idea that we would connect services to each of these homes and report back to the board and the engineer with what those fees or costs may be, even though we believe that there's no reason these wells can't be built. we don't have any suspicion that these wells are going to fail, or there's an existing well there now that works just fine. However, as a belt and suspenders approach, we are going to provide additional information regarding water service availability for those other homes through the conventional water service from the main out on Valley Road.
Okay, thank you. No, I was hearing all of that, but the comment had been made that if there were an issue with the well,
Sure.
So, you never know. Sorry, there was another question I think I had. All right then, thank you.
You're welcome.
Thank you. Okay, we've exhausted the public. Okay, so
Gave up.
Motion to close public.
what do we have? To let the public come back up? If the applicant's finished with testimony?
There's an interesting question here. We've got multiple variances being asked for, and I'm unaware that the gentleman who has just testified has himself a planning degree or a licensed is a licensed planner. Therefore, he cannot provide testimony, Mr. Coyce or Ms. Ball can correct me, as to variance requests because there needs a planner's testimony to support a variance request. You're looking at me like it's one of those nights.
I don't disagree with you.
Thank you. So I'm assuming Ms. Edwards plans on calling a planner at some point, because if she's not, she's going to have problems getting this application approved because we have no testimony that supports the multiple variances being sought. Ma'am,
Anyway.
you're going to have to move the mic closer to you.
Will do.
The base moves.
Man, that's heavy. Yes, we will call a planner. We do not have a planner. We do not have that to answer your question in as few words as possible. Yes, we will call a planner. We do not have a planner with us tonight, however.
Do you intend to call any other witnesses other than the planner?
We do not. If the board would like to hear from the applicant directly, we can certainly call, we can swear the applicant, but other than Mr. Farrell and possibly the applicant, we have no other witnesses tonight. We will return with a planner.
Tonight, we have reached the proverbial witching hour at 10 o'clock, and the board turns into Christmas trees at this time of the year.
And Michael's overtime kicks in.
So the answer to the back end answer to the chairman's question is no, we do not, because we have more witnesses, which then brings us to the issue. The time of decision is January 31st with an extension. Ms. Ball, because you seem to be the purveyor of the calendar tonight. Now, this is obviously tentative because the board has not formally approved the 2025 calendar. We will simply, you want to go to the...
Ms. Edwards, do you know do you have any time restrictions on, well, how long would it take for you to retain a planner, like in terms of some dates that we're about to talk to? Would it take very long for you to retain a planner?
We can probably retain a planner within 24 hours.
Okay.
Easier than engineers, apparently. We have 1 or 2 meetings in January, regular meetings.
We have one,
Okay.
and it's right after reorg.
Well, that answers the question. So the answer is the earliest we can place this application on the agenda would be a February meeting.
February 6th or February 13th?
Which would require then an extension on the application.
still in the state on the 6th? Okay. So there's no, just to be bold here, there's no opportunity to have us back in January?
No.
Okay. The applicant is scheduled to leave the country on the 5th of February.
Just clarification, do you intend to call the owner to provide testimony?
We would not unless the board had specific questions. My practice is always to insist that the applicant be present for the hearing.
We have
but
had
if it's the board's prerogative, if the board is not concerned about that, then we can make it a non-issue.
Board, I don't believe, has ever made the issue of the applicant's presence as necessary for an application to go forward. The issue is whether or not the board wants to hear any testimony from the applicant. If the individual's leaving the country around the time of the hearing and the board wants to hear testimony, and God, I hate to say this, this may be the moment.
I mean, I don't think, nothing at this point. I think the real question would be if there's anything that gets brought up at the future meeting and need consultation, that you may want to have the applicant on speed dial in the wee hours,
Can we reach you? Yeah. Okay.
So I think that's the only time you're going to need the applicant is.
What's that?
Communication system is very good.
Yeah.
You never know. I've been in situations
Counsel,
like this before.
When is your client coming back? When's he leaving? When is he coming back?
He leaves the 5th of February. When are you back? March 9th.
So then the only other suggestion to eliminate the issue is move to
March 13th then.
that would resolve the issue. It prolongs it, but it resolves the issue.
I would say, I think we would, if the applicant is confident that we'll be able to communicate, then and the board is okay with him being available by phone on February 6th, we would like that date.
Okay. February 6th it is?
Which would require an extension, would it not, Mr. Coyce?
Do you see the number?
Yes.
Yep.
TOD, right now it's January 31st, yes.
We'd ask for an extension to March 31st. The board would.
Granted.
You'll sign your paperwork in a minute. Therefore, Mr. Chairman, the request is to continue this application without further notice to February, determined 13th?
February 6th.
February 6th, 2025. The board will have to confirm this at the reorg meeting. February 6th, 2025 at 7 p.m. or soon thereafter, as the matter may be heard without further notice and extension of time for the determination of the application through March 31st, 2025. Unless we want to hold it like this. Then that is the new application, I gather?
It's private island. I make that motion.
A second.
Okay, roll call, please.
Mr. Wagner?
Yes.
Mr. Radowitz? Mr. Smith?
Yes.
Mr. Vitale?
Yes.
Mr. Depp?
Yes.
Committeeman Lapani?
Yes.
Chairman Chicarelli?
Yes.
Vice Chair Peason?
Affirmative.
Chair Surratt?
Yes.
Ms. Edwards, if you think you're going to need the engineer, he might want to be available. I'll leave that up to you, but the requirement here in terms of planner reports, in terms of any professional reports, is they are due here at least 2 weeks in advance, 10 days, 2 weeks. Which one have we?
10 days.
10 days, at least 2 weeks. Yes, roughly, let's say for the sake of discussion, 2 weeks.
2 weeks, I believe that's safer.
Before the end of January, so that the board can have it. It can go up in Civic Clerk. Mr. Coyce and to the extent Mr. May will have attempts to review it and produce their reports. They don't have the same time requirements, though.
Is it the board's requirement that the that a planner
submit a planner's
submit a report.
Right.
Okay, very good.
The board decided several years ago it no longer would sit here and hear a planner testify off the cuff without anybody knowing what he or she was going to testify
Fair
to.
enough.
Since we have been in the midst of this is an off night tonight for the board. This is the first night, and I cannot remember that we did not have a warehouse application on the agenda.
You're welcome.
Yeah.
And the last one for the year, because next week we're back on warehouse again, and the following meeting. So we require the planner's report be submitted in advance, including, and by the way, any other expert reports, if you decide now after looking at it that you
That we
need
need someone
a
else.
hydrologist or someone else of that matter, anybody you plan on having testify in an expert capacity must have a report in at least 2 weeks in advance of the hearing.
Very good.
To Mr. Coyce's office so it can go up on the, and some of your fan club will be looking for it,
No.
who are here tonight. They're gone, but that's the fan
Did
club.
we just vote on the resolution?
Good to have fans.
To extend?
Yes.
Yeah, we just voted on it. No, well, first, I'm just going to remind everybody that we do have a meeting next week, as Mr. Bernstein alluded to, so. That's it. No. So it'll be our last.
By the way, while I'm playing Beetlejuice, you all should have received another piece of the murder mystery that goes with the application, which is another report and set of plans from Mr. Ford, which I anticipate will drag this hearing on even longer.
All right.
So if you have not seen it, please check with Civic Clerk or contact Deborah. But I believe, and also, please bring, I know we're sort of still on, please bring the latest submissions you received from Mr. Gross, because that is going to be issue number 1 next Thursday night.
That's good.
Is whether he can have him testify.
Right. Okay, so with that, we got a meeting next Thursday night at 7 p.m. I will entertain a motion of adjournment.
So moved. Second.
All right. All in favor? Aye. We're adjourned. Good night, everyone. See you next week.